The Royal Commission into Defence and Veteran Suicide is now resumed. Please be seated.
Good morning, Mr. Singleton.
Good morning, Commissioners. Today's witness is Dr. Felix Seidel. He's the only witness for today, so we're hoping for a shorter than average Melbourne sitting. He's in the witness box. Before I introduce him in the usual way, might I just yield for counsel to announce an appearance?
If the Commission pleases, I appear on behalf of the witness, with the leave of the Commission.
Thank you. Sorry, what was your name?
McCready's my name.
Okay, thank you, Mr. McCready.
Commissioners, Dr. Seidel worked at the Department of Veterans Affairs as a medical practitioner in the role of medical advisor. Much of his work was in the role of advising delegates who were processing and determining claims under legislation for veterans' entitlements. Some of his work involved acting in higher duties, and you'll also hear about his work on aspects of veteran-centric reform through a component of that reform called OPI, which we will introduce to you. Might the witness be sworn or affirmed, and then I'll proceed with the tenders.
Do you, Felix Seidel, solemnly declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Doctor, could you tell the Commissioners your full name?
Dr. Felix Conrad Seidel.
I'll ask the operator to bring up today's tender list. Commissioners, I tender the documents on the list publicly or confidentially in accordance with the way it's been marked according to the usual way, but with these two qualifications arising from parliamentary privilege. I do, insofar as we are tendering versions of the statement of Dr. Seidel, I do not tender or read the following words from paragraph 156, quote, and the Australian National Audit Office, unquote. And for more abundant caution, and until we've reviewed underlying documents, at this stage I do not read from paragraph 37 the words, the community and public sector unions submission to this commission. Subject to those two things, we tender that material.
Thank you, Mr. Singleton. Sorry, Mr. McCready.
Yes, I've no objection to the tender of the documents. The documents have, some of them have arrived, but some of them have not arrived, or have certainly not, none of them have arrived in time for us to confer with the witness and raise issues that we may or may not see arising from it. And we don't in any way want to hold up the Commission, but if we could have leave to file perhaps a written submission, further written submission on behalf of the witness, if there are matters that we think ought to be brought to the Commission's attention, it would be in our submission appropriate.
Yeah, I can't see that being a problem, Mr. McCready. We're happy to hear from you at any time, even after the witness concludes his evidence.
Thank you very much.
Excuse me for one moment. Certainly there's no objection to the proposition of the way forward with a supplementary submission, and we indeed urge all people to contact us with information and submissions. We should just say that my learned friend and his solicitor only came into the matter in the last week or so, and we, upon the granting of leave in chambers, gave them access to the electronic system for access to documents. Some of those documents couldn't be uploaded until the Commonwealth had considered its position. Others have been in there since last week, but we don't cover with the proposition that they might have benefited from more time, and we have no objection and we indeed encourage any supplementary material.
Thank you, Mr. Singleton.
I don't think there are any other matters that need delays, so Dr. Seidel, I'll ask my...
Sorry, just before you start, I haven't actually accepted those the exhibit list into evidence. So we just for the record, they're accepted into evidence, and they'll be allocated the next lot of numbers.
Thank you, Commissioners. Dr. Seidel, did you make a statement dated the 1st of September 2023 for the purposes of the Royal Commission?
Yes.
Are the contents of that statement true and correct to the best of your knowledge and ability?
Yes.
And do you see a copy of the first page of the, I think if I called it a submission, I meant statement. Did you see a copy of the first statement, the page of the statement there with some of the table of contents?
Yes, I do.
Let me first just begin by asking you to introduce yourself. Did you join the DVA, or the Department of Veterans Affairs, in 2012 as a contracted medical advisor?
I did, yes.
And did you stay in that role for several years until about 2020? In 2015, you became a senior medical advisor.
Yes.
And for at least some 12 to 18 months before formally becoming a senior medical advisor, had you in fact become the de facto lead contract medical advisor, at least in Melbourne?
Yes.
Did you remain in the role of senior medical advisor until August 2017, and then for a month act as the principal medical advisor based in Canberra?
Yes.
And then in October 2017, did you take up the role of subject matter expert for the Operational Performance Improvement, or OPI, team within the Transformation Task Force for Veteran-Centric Reform?
Yes.
We'll come back to what that entailed. Did you leave the department in December 2018?
Yes.
Did you return to the department in April or May 2020 for a short engagement, once again as a CMA?
Yes.
Could you just... now, you're going back to the beginning of that summary of the structure. When you joined the DVA back in 2012, which team were you working with?
I was in the Melbourne office in rehabilitation and compensation, and helping or advising the delegates there for initial liability claims, as well as some permanent impairment across all three acts.
Now, we'll come to the detail of what the work entailed, but could you just give the Commissioners a brief introduction to what a medical advisor's role was?
Yeah, so the role essentially is to provide medical advice to delegates. So delegates will often have questions about clarifying terms that arise as the result of claims. Sometimes you'll review evidence as a result of claims, assist with impairment assessments, assist with directing what further evidence might be required. Essentially anything where the delegate sort of didn't have the medical knowledge to attend to that part of the claim, the advisor was there to assist.
Thank you. You say in your statement that you have come forward with a degree of reluctance. To the extent that you feel comfortable doing so, would you tell the Commissioners why you were reluctant and what motivation you have that overcame that reluctance?
Yeah, I think partly I'm reluctant just because I'm a private person and I'm not keen on having sort of public exposure of this kind. Partly I fear reprisal from some of the sort of people not directly referenced here, but they might see who they are, or this department as a whole might not appreciate what I'm saying in this statement. I guess that's the main sort of reluctance. In terms of the purpose, the reason I sort of overcome that, I guess, I think it's critical that things change in this space. And I think the experience I had hopefully fills in some gaps for the Commission as to what's going on inside the department, or at least what was going on.
Thank you. In spite of the negative aspect of the first part of your answer, your statement also emphasises the dedication of many DVA employees. Would you tell the Commission a little bit about your observation on the positive side?
Yeah, of course. So I think this is a point I want to be very clear on. Most of the people who I knew working in DVA were good people doing their job and doing their job as described. And I think the vast majority would be very happy to be part of an organisation that was more veteran-centric and did a better job overall. So I really am not here to sort of place blame on CMAs or delegates. I really see these issues as system issues and leadership culture issues. Does that answer the question?
Certainly.
Yeah.
Warren,
I guess you asked the positive. I mean, I don't cover it much here, but I mean, there are delegates and CMAs who sort of really go out of their way to do right by veterans, to make sure claims are approached in a fair way. Those people do exist in the department. I think, unfortunately, they sometimes have a tough go of it, is the reality. So that's not the path of least resistance, but those people are there and they do their best.
Now, we'll no doubt be using the acronym or the initial CMA throughout the next hour or so, which typically stands for Contracted Medical Advisor. But you've explained in a footnote that it's sometimes, the role was sometimes called, and I'll have to turn it up now, but well, perhaps you tell me, because CMA is used a few times.
CMA would refer to compensation medical advisor if someone was particularly working in compensation. An older term was departmental medical advisor. Within rehab and comp, all those terms were sort of synonymous.
In terms of being a contracted medical advisor, is it the case that you weren't, from 2012 onwards, employed by the department but were engaged through a contract for services?
Yeah, I was never employed by the department.
Did you hear, however, about what had been the employment type relationships with some of your predecessors in the years prior to your arrival?
Yeah, what my predecessors told me and what the sort of local management also said was that advisors, CMAs, used to be departmental medical advisors and employees of the department, and at some point the decision had been made to sort of make them all contractors.
You don't claim to have been a witness to that decision.
No.
But you were told various things about it that enabled you to understand that there were a couple of theories as to why the department changed from employing doctors to instead contracting with them. What were those theories?
And these are not mutually exclusive, but the two things that I'd heard were that a cultural sort of issue had developed with the doctors. I never got a good understanding of exactly what that was, but the department's solution was to sort of get a bit more control over them by making them contractors. That one probably rung a little bit less true to me, but it is plausible. And the other was that it was simply a budgetary tactic, that by getting these relatively highly paid staff and turning them into contractors, that removed them out of the operational budget. And the explanation given there to me was that our funds for us was sort of coming out of the administered budget, not the operating budget, and that allowed more freedom and I guess shuffled the books a little bit.
In other words, you understood that the department had two, I'll put this rather crudely, two buckets of money, one being its own ordinary allocation to run the department, and another being a bucket of money that was for veterans to give them compensation and other services.
Yeah.
And the shift from employing to contracting with the doctors meant that the department considered that it was entitled to take the remunerative expenditure from one bucket to the other.
That was my understanding of how it had worked, and the justification being that because we were sort of just providing medical advice, we fell within sort of medical services for veterans. My perspective on that was not really reflective of what we did. We were providing services directly to DVA, and we worked as integrated parts of the processing teams. We didn't have a lot of interaction with veterans, for instance. We weren't out there providing medical services. We were a core functional unit of DVA's day-to-day business in handling claims.
Thank you. You indicated a little while ago that the essential role of the medical advisor was to advise, and you've mentioned a couple of the different kinds of advice that you might be asked to provide. In your statement, you say that the role is best illustrated through some examples. Let's go through them. The first one you give is confirmation of a diagnosis and of the date of onset of an illness or an injury that may be the subject of a claim for compensation. Could you just step the commissioners through what advice would be sought and given and the context so we can understand what you were doing in that regard?
Yeah, and I'll use the sort of simple example I've used here. So when a claim comes into DVA for liability, there needs to obviously be established a diagnosis to assess it properly, and there also needs to be a date of onset for that diagnosis. That, particularly in Mercer and VEA, that's important because the statement of principles, a lot of the factors that can be used to accept conditions are time limited, so the date of onset is actually quite critical to whether or not the outcome is positive or negative for that claim. So a really common task that the advisors get asked to do is, here's some evidence, can you confirm what medical diagnosis this evidence sort of relates to, and what is the date of onset of that? The most simple is we would literally be given a GP report or a service medical record and pointed to a line that would say left ankle sprain or left ankle osteoarthritis or whatever it might be, and we would be asked to confirm that that is a medical diagnosis and the date of onset of it.
All right. I might just turn now to another part of your role, which was to interpret and also input medical impairment assessments. Could you tell the Commissioner what we mean here by a medical impairment assessment, what its role was, what inputting means, and how you assessed them or interpreted them?
So yeah, once initial liability has been accepted, there obviously needs to be an assessment of impairment to determine either what pension or payout is applicable. And so a role of the medical advisor was to take in the impairment sort of information. I might ask my counsel to not, sorry, I get very, very distracted by noise. So sorry, yeah, the role of the advisor was to sort of take the impairment assessment forms completed usually by a GP, a treating specialist, or via an independent medical assessment. And at its most basic, it was literally to input them into specific systems that DVA were running to sort of capture that, and then you'd print them out and sign them and give them to the delegate.
When you say inputting them into systems, you're actually talking about putting them into computer
systems, sorry, yeah.
This is data entry.
This is data entry. Depending on the quality of the evidence you got, that data entry might involve some translation of sort of the GP has said this, that fits here, that kind of thing. But a lot of the time it was literally, this box has been ticked. I pull up the right table and tick the corresponding box. There's a little bit more detail to it, but fundamentally it's just data entry. You're not doing much medical interpretation most of the time. Well, you shouldn't be, in my opinion.
I interrupted you. Did you want to say anything more about describing this role?
In terms of the impairment stuff and that task.
Interpreting the impairment reports. Where do these impairment reports come from?
Usually just from the department requests them from treating GPs, treating specialists, or as part of an independent medical examination.
Yeah, we'll come back later to an issue that arises in the use of these impairments where there are multiple claims and so on. But one aspect of this, you suggest that there would have been a better approach to have a direct input system for veteran doctors to complete these forms. Did you envisage that veterans doctors might actually have access to a part of the computer system?
Yeah, and look, the systems I started with, and probably the ones that are still being used, giving open access to GPs to that would not be a productive venture, I think, because they're not particularly user-friendly systems. But the idea that I put forward later as part of the sort of one of the bits of work I did with OPI was to try and, as much as possible, externalise the validation of the medical evidence, and ideally by building some kind of portal that allows GPs, treating specialists and independent medical examiners to input that information into a dynamic form and verify it on the spot, and then have that sort of filtered through to the delegate and basically say, look, as long as that information is falling within reasonable risk parameters, you might do some random sampling of it. But for most of this stuff, to just say, well, if the GP has signed off on it or the specialist has signed off on it, then we're going to trust what's in those reports and sort of externalise that process rather than having doctors internally reviewing them and translating them. So hopefully that is clear. But
And your view is, I withdraw that, just looking at it from a logical or hypothetical perspective. If GPs and specialists were regularly overstating impairment or in other ways being inaccurate, then it might be necessary to review every claim and then have you input the conclusion. If they were consistently accurate, then it would be a waste of money to employ you. I don't mean to be disrespectful, but a waste of money to employ you and your ilk to be reviewing what are satisfactory assessments in the first place. Having reviewed many over several years, what's your assessment of the level of inaccuracy or even fraud that the doctors were committing when assessing?
One thing I'll say first to frame it is I've got no way of knowing, to be honest, as a medical advisor, whether or not they were accurate or not. All I can sort of say is how many were implausible or really sort of pricked up my sort of curiosity is this is a bit extraordinary. It was very much the minority. So the vast majority of them just looked like they were in keeping with what you would expect for the diagnosed conditions, supported by the rest of the evidence, either the statement of the veteran. The vast majority of the time it was all simply consistent with what you'd expect. And my view on that is even where it's not consistent, that the recourse to change that cannot just be I, as the advisor, just change it, because my perspective as well, I don't have any evidence to do that with. We would need to undertake some kind of other process to figure out why this looks particularly extraordinary and whether or not that's just reflective of an extraordinary situation or something else going on. Fraud, I had no impression that fraud was much of an issue, but honestly I'm not sure that the DVA's sort of systems would have been capable of detecting fraud at any scale anyway. But from an advisor's perspective, I didn't read many GP reports and think this is the GP's taking a cut of these impairment payouts or something like that. I never had that impression. I will say very occasionally we would see quite extraordinary reports from some specialists that I felt maybe sounded like they were pushing the bounds of reality or didn't concord with the rest of the evidence, didn't sort of stated things that perhaps were very much contradictory to what was in the veteran's statements or service history, but they were very, very rare. And I think there's appropriate and inappropriate ways of dealing with those situations, but it's certainly not appropriate just to change the scores.
And when scores being a score of impairment against a table of that set out a scoring system.
Yeah, yeah.
The idea of having medical practitioners entering data, at first blush, seems a little odd, but correct me if I'm wrong, because you were there and I weren't, I wasn't, but is the implication here that not only were you inputting the data, but you were reviewing the assessment of impairment as you went?
Yeah, and the job as sort of taught to me was to sort of review it for, I guess, plausibility as you went and reduce those ratings as you went if you felt appropriate. Occasionally you might increase a rating if there was some competing bit of evidence where you thought that it had actually been underscored, but the vast majority of instances it was more about looking to see if something had been overrated and changing the score on the way in with absolutely no sort of communication with the doctor who had made that report. Very little justification needed to do it. It was simply, I don't trust this, so I'm going to change it. Was the sort of the way it was being done, basically. I did not like that way of doing things.
Let's just explore that a little bit more. One thinks one can understand the logic, but we want you to give the expert analysis of this. But let me put a proposition. If you are going to be reviewing the the impairment assessments of medical practitioners, one can see the logic of saying that looks implausible on the basis of the file and what's written down here. That impairment looks to be excessively highly scored, let's say. And therefore that impairment should not be accepted. That's one step. It seems, I suggested it is a very different additional step to say that the medical advisor, without having ever seen the patient, would be able to substitute an assessment of his or her own. One might think that it should be sent back for further assessment. The assessment might be queried, a further explanation might be sought, but not that you would put your own assessment in lieu of the treating physicians. Could you just comment on that two-step model, whether I'm right or wrong?
I mean, your description of it is essentially right. And yes, I think it's a sort of extraordinary way to do things, to simply have the medical advisor substitute their assessment, as you say, without any examination of the veteran, often without any good evidence to do so. Yeah, does that answer the question?
Yes.
Or do you want me to dig into something?
No, I'm grateful for that answer. We will come later to the topic of variability among assessors and teams and locations, but just flagging that we acknowledge that there are variations in approach. What can you tell us about whether, in fact, DVA medical advisors sometimes were substituting their own opinion of what the impairment score should be, as distinct from merely querying it?
It was common. I mean, it was what I was trained to do, essentially, by the previous advisors, was to, to look at some of these tables and say, well, that score is probably not right for that condition, or it's a bit much, we're going to just bump it down. I mean, it was very, very common practice to sort of, bump things down a little bit, basically, just on sort of some kind of proposition that it was not the right score. But honestly, I very quickly sort of formed the view that I'm not sure on what basis we're changing these. And then it depended how extreme that was. I think depended a little bit on the advisor and also the team they were part of. So some locations were, I think, much more aggressive was the impression I got than others in terms of how much they would modify ratings. I will say that, that the rationale for it, and I don't sort of agree with it, was, in theory it was to look at both the plausibility of impairment ratings, but also to try and look at competing evidence within the file. And sometimes there would be justifications of that nature. Things like, we're going to say reduce the amount of walking distance because somewhere else the veteran has said they're doing some particular activity that one might assume would involve walking longer than that. But again, my view is, well, that is not the kind of evidence you would use to dispute an impairment assessment by a specialist or a GP who knows the patient. And if you were going to dispute it, the process can't just be, well, I think I've got this idea that this isn't maybe right, so I'm going to change it on the way in, and that's the end of the story in terms of this impairment assessment. That never sat well with me, but that's essentially what would happen.
From a layperson's point of view, there seems to be a distinction between a correct medical diagnosis that an illness or an injury exists and the impairment to which it leads. For example, a fractured tibia leads to an inability to walk long distances, whatever it may be. Don't comment on that example because it's medically perhaps misconceived, but in principle, is it the case that there is a difference between diagnosing illness and diagnosing or assessing the impairment that flows from it?
It's certainly different things, yes.
And to what extent, well, I withdraw that. With respect to some injuries, is it not possible for a second doctor who has never seen the patient to confirm or rebut a diagnosis? If, for example, it is a fracture bone and both of you have the same X-ray, one could imagine that it would be possible to second guess some kind of diagnoses in a way that's far greater or far more possible than second guessing the impairment. Now, would that be right?
It's an interesting proposition. I think it's overall a reasonable one. There is probably more likely to be a difference in that assessment of diagnosis. Depending what you're talking about. I mean, if we're talking about fractures, maybe not. If we're talking about mental health, then absolutely.
So just to be clear there, it would be easier for two doctors, one to diagnose from an X-ray, but you really need to see the patient before diagnosing a mental illness.
I think absolutely.
I know it's general, but
I guess I'm also, there's much more likelihood of there being variance between, one psychiatrist to another or one GP to another between a mental health diagnosis than, say, a fracture, which is, objectively found on an X-ray. And then there's everything in between for various other diagnoses. Whereas impairment, there's probably likely to be a bit more consistency overall, just because that is more related to the reality of what's going on for the veteran and something that's a bit more observable rather than, we can argue about whether something's adjustment disorder or depression or something like that, but it's a little bit easier to have consistency on how's that actually impacting the person. Does that, so etiology is sort of that concept you're talking, I guess we're getting to, and impairment's a bit easier.
penultimately on this point, were veterans or their treating doctors told that the doctor's assessment of impairment had been changed?
Almost never.
So that the veteran might receive a compensation payment of a lower amount than would have flowed from the GP's assessment, but never knew that the claim had received a poorer outcome on the basis of a decision made within the department as described.
Yeah, this process was essentially silent with regards to that. It was very uncommon for us to ever sort of call the GP to clarify, and as far as I was aware, there was absolutely no process to notify anyone that those sort of judgments had been made. there was often very little even documentation as it was happening. Some doctors would sort of document those changes within the impairment assessment and say, this is why I've changed this rating, but that wouldn't happen universally. I wasn't aware of any sort of procedure in which we'd actually go back to the GP. And I think most GPs, specialists, would have no idea that their ratings have been changed. And I think in a lot of cases, veterans, unless they really reviewed things very carefully, I think it'd be very easy for a veteran to miss as well in the sort of complexity of those assessments and how they come out. They're not easy to read if you're not used to reading them, basically.
And finally, on this little topic, you suggested a better approach of a direct input system. We've mentioned that before. Arguments were raised against that, arguments to justify the status quo. Do you recall any of those arguments and what you thought of them?
In terms of that we can't do a direct input?
And you can't allow the GPs to do a direct input.
To be honest, I don't recall. I don't know whether those discussions would have happened. It was never an idea that I had much success in pushing forward. The one I can recall was just the idea that my description of dynamic forms was science fiction from one of the sort of mid-level executives. I don't recall other specific stuff about what would be sort of how GPs, what would be wrong with having GPs or specialists do it. I can hypothesise as to what the response would be, but if you've seen something, is there a bit of evidence I haven't seen in regards to this? Or
We'll display something for your benefit. If I could just ask that the witness's statement be brought up at page 8 and highlight paragraph 29. Here you say that you suggest a better approach would have been to have a direct input system. And about halfway through, at the end of one line, you say, one argument sometimes put forward to justify the status quo was that GP assessments needed review because GPs didn't understand the questions or weren't qualified to provide medico-legal reports. I wanted to get your response to the validity of that argument against what you suggest would be a better.
All right, so I delved into the specific discussion around sort of building an IT portal. This was a sort of a common refrain in the department was sort of these GP reports are bad because GPs are misinterpreting things and writing the wrong thing down. And to be honest, they were often really messy, but I don't think that was the GP's fault. And then there was this sort of other argument that, the GPs are not capable of doing this kind of reporting, that it's either not reasonable or not appropriate to expect them to do it. I guess the counterpoint to all that is that's what was happening. It might not be unreasonable to say that we shouldn't expect GPs to do medico-legal reports as part of their day-to-day sort of work. But if you're sending them out reports and you're relying on them, it's a sort of a different scenario. But does that clarify things? Apologies.
No, that's all right. But let me just take it one step further.
Yeah.
Let's assume for a moment that the GPs, at least sometimes, were not experienced in a legal context and didn't know how to format the reports properly. You said some of them were messy. Let's just assume that that was a reason for not trusting the reports and having a second opinion substituted. Can you see any basis at all for determining a veteran's claim for impairment on the basis of a conclusion on the evidence that the veteran's never told about and cannot challenge on appeal?
No. Do you mind if I just add,
please,
just some clarification when I say messy? The GP reports that were being sent out in my day, they may have changed. Ask the GPs a series of direct questions to ascertain the sort of impairment information. And it wasn't necessarily uncommon to see that they'd either been done with time pressure, so they were rushed. They were usually handwritten, so sometimes it was hard to just read the handwriting. it was that kind of mess that you'd see. Not that they were being asked to type up sort of new reports, but just you could see that they hadn't had adequate time sometimes, or that they just had been asked questions within these impairment assessment forms that maybe were confusing if you hadn't had any pre-existing experience with it. That doesn't have a material outcome on them sort of ticking the box for the veteran can't walk 50 metres. That's not really the issue, I think. And there's no real reason I see why you can't get that information from GPs, because all of the stuff you're looking for is ultimately about the veteran's capability and function and health. And I think GPs are perfectly capable of actually asking the medical questions that underpin that. But it's about presenting those questions in a way that is going to get them get a response that is sort of coherent and easy to deal with. But to my mind, that's DVA's responsibility. If you send a GP a form that's hard to interpret and it comes back a little bit confusingly filled out, well, it's not. I don't think that's on the GP.
One of the proposals about which this Commission has heard is that GPs and maybe other medical practitioners might be given particular training in the needs and issues facing veterans and in DVA processes or rules to the extent relevant, and might be accredited as having done that course and might then do the job a little bit better. From the perspective of a claims processing CMA, might such a scheme of training doctors, who would then be recognised and might even be remunerated, help the claims processing system work more efficiently?
I think it would, absolutely. My only comment on that is if you're just talking, I think it's a great idea in terms of veteran health. If you're talking about just claims processing, I think it's probably both unrealistic and unnecessary to have GPs be sort of qualified to fill in the reports, because
That's actually a different proposition.
it's a different proposition.
It's whether it would help if at least some of them.
I think it would definitely help if there were GPs out there, and if it was sort of more complex, or the veteran felt they really wanted someone who knew this work. It would be great if we had accredited GPs who really understood the system. But equally, I think there needs to be a responsibility on the department to build input systems that make sense for any doctor, because the information at core is not, they're not complex questions in terms of every GP should be able to answer most of these questions about how their patient is.
Well, I do have to ask the question that every layperson has always wondered. Are doctors better able to read each other's handwriting than the rest of us can read your handwriting?
No. I was sometimes asked just to, it sounds absurd, but sometimes just asked by a delegate just to interpret doctors' handwriting, particularly in the defence medical records. I was bad at it. I'm not very good at it.
I mean, in fact, a doctor might be able to recognise a medical term that the rest of us wouldn't. And
Yeah, so we have that advantage, but in terms of actual handwriting, no.
All right. I think everybody has always wondered.
Yeah.
But I go to the next example of the kind of work that you do and see what issues we might find. It's a slightly smaller one. Guidance on further investigations and resolving ambiguities.
Yeah.
What work did CMAs do in that respect?
Yeah, so this is where there might not be enough evidence on file to ascertain a diagnosis. That's not necessarily uncommon. And there might be a question over what's the best next step. Is this something that's going to be best resolved by asking just for GP reports? But if so, which reports to ask the GP for? Because there's a whole list of different questions. You don't want to send the full bundle of 100 pages to every GP for every possible condition, so you have to narrow it down. So sometimes there's the job of saying, look, you better ask these questions of the GP, and that applies to specialists. And sometimes it's a little bit more complex in figuring out, well, what specialist would we actually need to diagnose this and that's not applicable to the bulk of claims, but for claims that involve sort of rarer conditions, there's a little bit more involvement in saying, oh, if we don't have this, we might need to get it in order to sort of verify the diagnosis here. Because I guess the background of that is just that veterans are not obliged necessarily to claim a specific diagnosis, and so we would sometimes get pretty general claims that needed a bit of a direction in terms of how do we resolve this one.
In a few minutes, we will come to a wholly new topic, which is why delegates seek medical opinions in the first place. And of course, it interrelates with what we're talking about now, which is the kinds of advice you do give. But is there anything in principle or often in practice where you found a problem with giving guidance on further investigations or resolving ambiguities? I'm not suggesting there should be a problem, but was there?
Look, overall, not in principle.
No.
Certainly, you'll find instances of problems arising out of it, but not in principle. It's quite a reasonable thing, I think, particularly for the rarer conditions, for the delegate to ask an advisor, like, what do I do here? What evidence are we seeking? Obviously, that should be done in the context of what's going to work for the veteran as well, trying to get reports from treating specialists and whatnot. It's not reasonable in principle, unreasonable in principle at all, I think.
The next example you give of advice that you might be giving to delegates was simply translating medical terminology and concepts. In principle, a reasonable thing to do. Would that be right, in principle?
Yeah, absolutely. I think
Do you have any
role.
particular comments on the way that worked in practice and whether it was that role was being sensibly used or not?
I think it's a valuable thing and a necessary thing for any organisation that's dealing with the volume of health information that the department does, to sort of have people there who can translate and interpret the terms where necessary. I do think over time the simplicity of what we're explaining increased, if that makes sense. So I think when I started there, most of the delegates I was working with were pretty experienced in the kind of questions they asked. While maybe the written opinions were a bit simple, they would know the basic terms. They would know what lumbar spondylosis is, which is something you deal with every day. As we went on and we got more delegates in, and the training, I think, got a little bit more haphazard for them, at least in my view. The sort of quality of those questions sort of reduced, if you like, and the sort of medical concepts we were being asked to explain got to the point where there were the things that you would expect a delegate to probably have been trained in and know. If that does that sort of answer your?
Yes. Well, let me just pick up on that last point. Is this right? When you were first there, it appeared that delegates did have some training in medical terminology and therefore ask questions of a more obscure kind rather than wasting your time with things they ought to know?
Yeah, I'll divide that into, so there's sort of informal questions and formal questions. So the written opinions didn't change that much, but there's other reasons why experienced delegates still ask for clarification of diagnosis. I imagine you'll ask me about that later, but in terms of the sort of informal ones, like I don't understand what this word is or I don't understand this concept, I think there was a noticeable drop in sort of the basic medical understanding of delegates in the time I was there. No fault of their own. You can't expect people with a law degree to walk into the department and, a month later be able to understand all these terms.
And yes, it's no criticism of the workers.
No.
It's an issue of training and management. Yeah. But when you refer to the time you were there, you were in the role of CMA and then SMA from 2012 to 2017 and then moved off to OPI. Had that noticeable drop of knowledge that you mentioned occurred by 2017, or are you talking about the whole period through to the end of 2018? Is there no real difference in that last year?
I felt it was basically just an ongoing drop. So when I came back for the short stint, helping the Perth team for PI, the impression there was the delegates unfortunately didn't really understand medical concepts.
Do you have any insight into why that drop was occurring over what now appears to be about a period?
I think much more labour hire was used, and then I think whatever it said on paper about how much training was occurring, I think the strong impression I got from delegates and from the work I was doing, where I could see sort of where their medical knowledge was at, they were just not being provided with the training and the support to understand these concepts. And also the other sort of aspect of this is the pressure for them to do more and more claims. And when you do that, you quite necessarily reduce their ability to sort of engage in training, and so their time and energy to actually learn these things, I think, just reduced more and more over the time I was there. That the teams expanded really quickly, and a lot of the workforce ended up being labour hire. The other thing is the attrition rate. I can't quote an exact figure, but the attrition rate ended up being quite high. So you have this huge sort of turnover of delegates. That's not an environment in which you're going to end up with, a workforce that is well trained in the real detailed aspects of the job.
The final part of your list of types of advice given is providing opinions on causation. You make the point that was only relevant to CIRCA claims and VEA and MERCA claims where there was no statement of principles to apply. But could you just briefly introduce what that work entailed and let us know if there are any significant issues with that part of your work?
Yes, so that works. So when something doesn't have a statement of principles or under CIRCA, there needs to be a medical opinion given as to what caused the condition and in the context of the contention of the veteran as to what caused it, so that the delegate can make a determination as to whether or not that illness or injury or disease is related to service. And so it's it's one of the important roles of the advisors really is to have a look at the medical evidence and to provide some analysis on causation. And it's not something that I think should always be externalised, mainly because it's not always necessary. For instance, in CIRCA, I think it's quite reasonable to use internal advisors to, for instance, verify that this person's osteoarthritis of their knee, yes, has a causative relationship to these activities or these injuries that occurred on service without having to push the veteran to go and see their specialist and have them provide that report. I think a lot of the time that's sort of unnecessary. And then in other instances where there are things being claimed that were quite unusual, it's helpful to have someone there who can provide some understanding of what might have caused this, and then that again determines further investigation. It all should be done sort of working with the veteran, not against them, but I think it is a valuable thing and something that any organisation that does this work is going to need. There are certain gaps that we need to be filled by expert medical knowledge, and that's sort of one of those tasks. I will say though that the other option is just to send it to specialists to give those opinions, and that happened as well. In those cases, the task of the advisor is a lot simpler. Ideally, just agree with what the specialist has said, as long as it's within the bounds of plausibility, which it almost always was.
Were CMAs given any training, or did they develop knowledge about what service life was like to help them with this work?
No, there were attempts later on. So initially, no. So I was given no such training. There were some attempts sort of driven by the doctors themselves, and one particular advisor did a really good job of trying to drive that idea that we'd get some training. I'm not sure whether it ever became something sort of really enshrined in the department that all advisors get that training. It certainly wasn't something that happened for me.
And when you say it didn't happen at the beginning, but it never happened at all?
Not really. I mean, parts of my role sort of certainly expanded my view in that regard, and I did attend one, that there was some internal efforts, which I attended to have some veteran perspectives sort of come into the department. So it's not like that was totally absent. But whether or not you describe that as being a structured part of the CMA training, I was sort of beyond the point where I would go back into the core training. I'm not sure whether it was ever instigated or not.
So far as you know, it may or may not have been introduced as part of the structured training, but if it was introduced, it wasn't retrospectively applied to the CMAs who are already...
No, and it certainly wasn't I certainly wasn't required to do that when I came back in, for that last stint. It's not like they said, you better do this new training module. I just want to make one comment around that. It may be possible that there's an online module to that effect that we did. I wouldn't remember, and I wouldn't remember anything that was in those online training modules. There were certain, workplace safety things we had to do at one point. They're not the kind of training you deploy if you really want people to understand the topic. They'll tick the box kind of thing. So it might be in there, but I would suggest that's probably not sufficient for the purpose.
Having heard a list of the types of advice that you were called to give, I just want to turn and look at it from another angle. Not what the delegates were asking you, but why they were asking. In your statement, you broadly group reasons into two categories. One is, you say fairly straightforward, just the inherent complexity of the medical evidence. That's, with respect, easily understood and explained in your statement. But I want to go to the one that you say is trickier to dissect, what you call departmental culture and procedural habits. That second group, the cultural, procedural reasons for asking advice, could you just take us through what it was about the culture of the department and its procedures that led to delegates coming to doctors?
Yeah, so I think the easiest way to understand this is to sort of understand the management style and the leadership culture, which in my view was really not very supportive of delegates in their work, and particularly if errors occurred, I really didn't see that as something that was constructive for, used as constructive learning experience for delegates. And so you had these workforces that were under a lot of pressure to process as many claims as possible, as quickly as possible, who I think, and I guess I'm speculating, but at least from what I was told from delegates, didn't feel like they'd be supported, felt like they had to protect themselves as much as possible in their decision making. And one way to do that, I'm not sure it was that effective, but one perceived way to do that is to basically ask an advisor to verify any piece of medical information, because at least that, for the delegate, that sort of externalises that verification within the department, meaning that if they're pulled up on a decision or something like that, at least they're not going to be pulled up on you made a sort of a medical call without consulting a doctor. Now, I guess you could say in principle delegates shouldn't make medical calls without consulting a doctor, but these are very simple things that you would expect delegates working with this kind of information to understand. And I think a large driver was just that fear, rather than I really need to ask this question. And then later on, as you get less experienced delegates, it's a combination of fear and ignorance, I guess. That sounds insulting to the delegates. That's not the intent. It's just...
Your point is about the management's failure to back the delegates.
Yeah, they didn't back they weren't backed in my view and experience, and they were just in a really tough spot. And one strategy to navigate that is to just send everything for a medical opinion. The other thing is sending for medical opinions, I think for some teams had a structural purpose as well, in terms of when you send something for a medical opinion, it sort of gets it off your desk for the period it waits in the queue, and that frees up a little bit of space, and there's a little bit of diversion of that work. Again, no fault of the delegates that they had to do it that way, but there is a way to sort of use the doctors to sort of augment the work of delegates to push through more claims, and I think that was part of it as well.
We might just come back to that. Pause. Try and give the Commissioner a sense of the workplace. were you in an office or a workstation or some other? This is when you're a CMA or an SMA doing that work.
Can I just, before I ask that,
Yes.
should I be directing my answers to you or to the Commission?
Oh, just talk. You and I will just have a conversation. Occasionally, someone else.
Excuse me, I'll just. I'll face you so my neck doesn't get crooked.
Look, it may well be you feel more comfortable talking to somebody else, but
sorry, do you mind just repeating it?
yeah, I was just going to just try and give a practical description of the workplace. An office, a workstation. Who was sitting around you? What you could hear.
Yeah, so it's an office not too far from here in Melbourne, occupying sort of one floor, although the specific IL and compensation teams didn't occupy sort of probably more than a quarter of the floor when I initially got there. They slowly expanded to occupy almost the entire floor. It was an open plan office except for a couple of the EL2s. I think one or two EL2s had a sort of a closed office in the centre. Everyone else, it was open plan. You could hear people talking. It was a relatively sort of open environment, I guess.
Were you sitting in a section of the office which was just populated by CMAs, or were you mixed in with delegates? Or?
Initially, I was seated with other doctors in one of the sort of cubicles, but just I moved about quite a bit, to be honest. But the next pod along would be a group of delegates, and initially the next pod along was sort of the EL1 managers on the other side. Yeah.
How physically would you get a request for advice? Was it an email, a piece of paper? You went to a filing cabinet, someone came and talked to
Initially,
you?
it was a filing cabinet filled, because at that stage DVA was still using paper files. So it was a filing cabinet filled with opinion requests, and the job was just to take the next one in line, pick it up, see what it was, and work through them. And then usually what we do is take that back to the specific delegate. I don't think all doctors did that all the time, but I found it was a good way to get to know the delegates, to sort of take it back and clarify anything that needed clarifying. And then you just go to the queue and pick up the next one.
By the time you left, was it still a filing cabinet system?
No, that they'd converted to, it had all been digitised, and they were using something called ISH. In my opinion, it was harder to use the IT systems than it was to do the paper files.
How would the system actually work? Do you get a message flashed on the screen, or did you have to
No,
go into a system and find out what the request
when I was
were?
using it, there was a queue, and you'd sort of you'd manually pick up a file out of the queue within the IT system.
Right.
So it wasn't sort of you weren't directly assigned files. So it's very much the way I'd sort of describe it is ISH is like a digital emulation of those manual processes. So it wasn't necessarily a true transformation to a new way of doing things. It was really, this is what we were doing with paper. Let's sort of just do that electronically. If anyone has ever used those kind of systems, they're not easy to use. It's much harder to read a large PDF on a computer than it is to have a printout.
In either the paper or the electronic system, was there any management of the queue so that simple things were done slower or quicker, or could it be manipulated by those who wanted to improve their stats or anything like that? Or is it just a first in, first served? How did that?
Initially, there was not much management of the queue. It was just put them in, and some delegates would sneak their opinions to the front of the queue at times. There was a bit of gaming of the queues. When I sort of started leading the CMA team, one of the things I did was start to try and organise those queues a little bit better, and try and avoid as much of the gaming as you could. Within the electronic queues, yes, there's organisation of it. It's split up into impairment assessment versus IL and all that kind of stuff. I can't remember, to be honest. I think it's a little bit harder to game the system within the IL, within the electronic queues, but I think it was still possible to sort of pick up, not just to pick up the next one.
You've mentioned ISH, I-S-H.
I think it's Integrated Service Hub, and forgive me, I'm terrible with acronyms.
Just turning back then to the reasons delegates seek opinions, and you've mentioned how they in effect insulated themselves from potential criticism, or tried to. Your statement says there was a second reason, which you've labelled as internal power dynamics, which fostered a greater reliance than necessary on medical advisors, leading to certain parts of the organisation being more powerful. Could you just outline what you're talking about and why that led to the outcome?
So this is, obviously speculative on my part, but my view of what occurred was that the Melbourne team in particular realised that you could actually use advisors to push throughput. That might have partly been my doing, because I sort of made changes when I first got there in how I did the work that sort of made things a lot more efficient and cleared a significant backlog really quickly. And from there, they started hiring more and more advisors. Now, that sort of happened in concert with taking over more and more work from other states. And I think, my strong impression was that the advisors were seen as resources or valuable resources in a strategy to sort of expand the sphere of influence.
If you've got more resources, you can process more claims.
Yeah.
And then how does that help you in the organisational power play?
Well, within that, then you can take over work from other states, basically, and that sort of happened via a state would have a backlog, get behind. They'd have to ask for assistance. Melbourne would say, well, we've got an excess of advisors and we can lend a few delegates to this problem. But then a few months later, Melbourne would have just absorbed that entire work stream. And that was sort of the process that would occur. And then that gives, I guess, that office more security in the dynamics of sort of change. They're less likely, I guess, to be shut down. And also those particular managers then have more influence within departmental processes, I assume, are more likely to get promotions because they're managing larger teams, all that kind of stuff. Office politics stuff, basically.
Move to a different topic, clinical governance and the administration of the medical advisors. You make the point that there was resistance to having the principal medical advisor be responsible for the medical workforce, and you've just mentioned that you were seen as assets of processing teams. Could you introduce the commissioners to the issue of clinical governance and the cohesive medical leadership and why that might be important?
Yeah, I mean, fundamentally, you've got a team of doctors doing what is, it's medico-legal work, but it's very much dealing with medical concepts, providing medical advice, and usually the way you would approach management of those kind of situations where you have, expanding teams of doctors, is to have a process of clinical governance to ensure that there's consistency of approach, to ensure that errors can be dealt with in a constructive way, all the sort of, usual stuff you'd see with any sort of dedicated specialist team. In medicine, we call it clinical governance, but it's essentially just making sure that there's some quality control on what those doctors are doing, and there's a sense that there's a mechanism for continuous improvement of those teams.
You may have covered this. I apologise if I'm covering a bit of ground, but if, just in case, was there a difference in the way the delegates interacted with medical advisors, depending on whether it was an initial liability issue or an incapacity or permanent impairment issue?
In what sense?
I just want different degrees of reliance on the medical advisors or different types of questions.
Yeah, so in the PI space, the reliance sort of, apart from a little bit of circa PI at the start, the reliance basically became default. That is, if you had an impairment assessment, it would be given to an advisor to verify. With regards to IL, there was a lot more variance, in what a particular delegate would require, how mature the sort of evidence would be before they would ask for assistance from doctors. Big differences in their capacity to identify risk early and seek help early versus delegates who maybe didn't identify risks and then would seek help late, once the veteran might have already been sent for an unnecessary report or something like that. So probably there's a lot more variability in terms of that function within the IL space.
All right, I'll just want to ask about medical reports. In your opinion, was there a policy or a consistent approach to the way treating practitioners' reports were used?
There was a policy that we were meant to use them where possible, or that the department was sort of, meant to use them where possible.
And in practice?
In practice, it was variable, again, depending on the teams, depending on the advisors, depending on the sort of local culture of those advisors. So some medical advisors and some teams were much more keen to send veterans off for independent medical examinations to verify what the treating GP or specialist had said. So I guess much more inherently sceptical of the evidence that was coming back. Others were much more comfortable saying, well, if this is what the GP has said, well, that sounds reasonable.
And did that kind of variance seem to turn on the strength of the evidence, the personality of the delegate, the structure of the department, or something? What led to this sort of variance?
Yeah, the variance in terms of, there's two different types of variance there. One is between the sort of medical advisors. My impression there that turned mostly on what local culture had developed within that advisor team. So the advisors in any given location would sort of form a de facto team, and the tendency for doctors in those situations, I think, is to form some kind of consistency. Not to say that there was absolute consistency within those teams, but then there'd be, depending on who had, I guess, the most influence as the doctor within those teams, there could be huge variance between how a team in Melbourne and versus a different state might be approaching really common issues. Between delegates, the variance, there's definitely variance between different processing locations, but equally there could be variance between individuals within the same team, or between different teams that had different team leaders. And that was sort of dependent on training, on personality, on whether or not they sort of had, I guess, an inherent sense of procedural fairness or compassion for veterans, those kind of factors, or whether they were more inclined towards cynicism and skepticism. All of that played a huge part, and it was, I think, to a large degree, sort of blind luck where a particular veteran's claim landed as to whether or not they'd get someone who would view it, one way versus another way.
And forgive me for being too obvious if I'm right about this, but if it's blind luck about where your claim lands, that is by whom your claim is going to be assessed, it's a blind luck as to how successful your claim is going to be compared with the next person who might have had his or her file go to someone else.
Yeah, blind luck in terms of success, but also in terms of those, impairment modifications. So whether or not, how your impairment assessment's going to go, how many IMEs you're going to, are you going to be asked to produce more evidence? Any variable that you can think of that might occur in the claim applies to that. So it's blind luck on all fronts. and a lot of random variation, to be honest, within that. You know, you might be more likely to be successful ultimately for your IL claim, but also have to endure way more reports to get there. You might not have to endure any reports, but your claim's going to get rejected outright based on what you've put. You might be exposed to, you know, accepting the wrong condition. You might not. And it's not predictable how that's going to occur.
No, you were there for 8 years with a gap towards the end, but so in answering this question, factor in that there may have been a change and tell us about it. But the question is this: what structures or systems did the DVA have in place to try and get consistency, to check whether these differences were occurring? In other words, to counter the element of blind luck that veterans faced?
Well, initially, very, very little, even in the way of sort of nominal systems for that. There was basically just quality assurance systems that would do a sort of random sample and, in theory, lead to quality improvements and pick up problems. In terms of any constructive change, I didn't really see any. You know, there were attempts to institute sort of better clinical governance for the advisors in particular to get consistency. And I think to some regard that was successful in getting a bit more national consistency across how advisors approach things. You know, one of, I think, Dr. Ian Gardner's sort of initiatives at PMA was to try and start that process of having a national identity for the advisors and get consistency. So I think, you know, that's probably one area where things may be a bit more successful. In regards to the blind luck, though, I think it's still, at least when I was there for that last stint, basically still applied. I was seeing, you know, I was in the permanent impairment, so I could see what was coming from IL, and there was huge variance in similar claims would have been treated differently by different IL delegates depending on, you know, their experience and their perspective on how to approach things.
You did refer to some quality assurance by way of random samples looking for problems. Was the nature of that sampling and that analysis one of looking for problems in the individual case, or did it address the question of variance? Because one can imagine a range of correct possible outcomes, and the answer is yes, that was in the range or not. That's quite a different question from whether there's consistency across the organisation on similar matters. Did it address the latter?
To my understanding, it did not really address variance. It certainly, even if it did nominally, I didn't see any evidence that it had an effect on variance. And my impression of most of the quality assurance processes were they were really about, I guess, they were a mechanism to sort of instill a little bit of fear, basically. That was something that, you know, delegates found incredibly stressful if they got picked up for an error. But I didn't see that as something that constructively changed, you know, that variance or improved quality per se.
Was there any variance between some, or depending on the nature of the medical issue, and I particularly would ask you to focus on whether PTSD claims were treated differently from what was more typical?
Sorry, could you repeat that?
I'll be a bit more blunt about it. Was it common practice to reject PTSD claims on the basis of the medical report not adequately demonstrating that the condition was stable? I'll just ask that narrow question first.
That narrow question, yes, I think that was a relatively common occurrence.
Now, in fairness, the legislation itself refers to the need for some stability to have been achieved. What, with a condition like PTSD, are you able to comment on how in practice the legislation works?
Yes, I mean, I took, I'll explain that and then explain the sort of approaches. In practice, I guess you can see two versions of how delegates and advisors approach that issue. One is to sort of separate the sort of, the stability of the diagnosis in terms of impairment from the diagnosis itself, and say, well, we definitely have we have a clear diagnosis of PTSD. By its very nature, there is going to be fluctuation in the impairment. Therefore, we have to start making some reasonable assessment of where we're at with it, but that doesn't mean we sort of reject either the PTSD or the impairment outright. And the other approach, I guess, is to say, well, if the psychiatrist has not ticked the right box or said the right thing, we're going to either reject that claim outright, or when it comes to PI, we're going to give that veteran nothing on the justification that the impairment's not yet stable or permanent. It's a very tricky thing, I think, to judge. But my view was generally that it was a bit absurd to sort of use that secondary reasoning when it was clear that there was probably at least a minimum impairment going on for most of those reports. And most of the time when a psychiatrist has diagnosed PTSD and they've said this is the impairment associated, it is fluctuating, but this is sort of where the baseline lies. I mean, I think you can reasonably say, even if they've said, it's not permanent and stable, probably because they haven't quite, they don't have the background training to understand what that technically means legally. I think the reasonable approach is to sort of, a positive thing an advisor could do there is say, well, hang on, we've got enough evidence to put in place that this minimum impairment at least is reached. We can go back for more information, but we should not say, let's give the veteran nothing and that's the end of the story. I hope that answers the question.
Sure, but can I just follow up when you say it would be reasonable for the advisor to give that advice?
Yeah.
How commonly were claims resolved in that way?
That we would sort of give that advice that there should be a minimum here, and or that this is justified.
Basically, instead of, as I understand it, and correct me if I'm wrong, you're saying that one approach would be to say the condition is not stable, legally we can't grant the claim, there'll be no compensation for now. Another would be to say, well, although there are these fluctuations, for the purposes of the legislation properly applied, we can say that there is sufficient stability now reached and compensation can follow. I think you're saying the latter approach was a better...
In my opinion, yeah.
Now, better firstly for veterans.
Yeah.
And secondly, you say a better application of the law.
In my opinion, yeah.
Is that the way it was commonly done?
It would depend on the team. It was not the way it was commonly done. I think when I started there, that was the approach I chose to take when I began to actually understand the issue. That's the approach the people I trained to take, but I was aware of other locations that had a very different take on those issues. And so again, there's that element of luck. One of the issues with answering questions like that with any sort of clarity is the lack of data around these things. So I can't say I can say that, definitely there were locations that took a very different view to me in terms of what the right thing to do there was. But I can't tell you with any certainty what percentage, when we tried to change those approaches, when we tried to get sort of some national consistency, very hard to tell you whether or not everyone sort of complied with the approach that I was advocating for.
But some were and some weren't. Is that your?
Yeah. I mean, I think it would be. I don't think everyone would have taken that approach. Not just on the basis of me saying it was the right way to do it.
No.
Yeah.
I'll just go to one other example of the way you did it differently. You took the view where a query was raised with you that some queries could be answered quickly on the basis of just checking the critical evidence, not reading the entire file. Just to explain when you would apply that approach and when you wouldn't.
Yeah, so I would apply that approach to sort of be efficient when it was medically clear. So when the question being asked was easily answered by the sort of readily available evidence, and that I detected no sort of threat to the veteran in terms of that claim or otherwise, in terms of just accepting it or accepting the diagnosis as given based on what was in front of me. That assessment required sort of understanding the broader context of things, and it also required talking to delegates. And so particularly until I really learnt these issues, I would often go to the delegate and say, look, I've given this opinion, I'd have basically a verbal chat. I'd say, look, here's my opinion. It is just based on, I've reviewed the x-ray, I've reviewed the claim, I've reviewed the relevant documents you've given me, but I have not read the entire file. Do you identify any issue with proceeding with this? Is there something I've missed? Is this going to, for instance, is this going to result in a rejection? And some people might say that as, that's outside of where the advisor should be considering. But my perspective was, well, if it's going to result in a rejection, then I am obliged to read the whole file and make sure I haven't missed anything. But if it's going to result in an appropriate accept that has no ill effect on the veteran and it means that claim is processed quicker, then it's a reasonable thing to do. That's the approach I took. Maybe not everyone will agree with it, but I got there in the context of a very large backlog of opinions and thought that the notion of spending hours and hours on every one of them was not sort of reasonable when a lot of them could be answered very quickly, saying we've got an x-ray, we've got a date of onset, the delegate confirms that's a positive result for the veteran, there's no risk here. I thought that's pretty reasonable to actually get this work done rather than sort of labouring over these decisions.
To what extent can you comment on how many advisors and delegate teams, the pair of them, would take that approach?
When I started there, I was, to my understanding, I was unique in doing it that way, so that the training, most of the people I initially worked with would read everything. And again, some teams, many years down the track, or some years down the track, when there was discussion about introducing KPIs for medical advisors, were adamant that you needed hours for every single question because you had to read every single bit of information to answer them. I did my best to at least train my team in Melbourne that you need to know the parameters of these. You can't just have a new doctor kind of start and do that blindly, because there are pitfalls. You need to have good communication with the delegates, but if you've got those safety measures in place, that's how I trained people to do it, because there's an emphasis on sort of actually doing these things in a timely fashion.
Your statement tells us about something called claims splitting.
Mm-hmm.
Can you tell the commissioners what it is, when it's appropriate, when it's not?
Yeah. So claim splitting in this context, and as I say in the statement, there are other contexts, but this is really the idea that a veteran will put in a claim that contains, I guess, what I'd call multiple subclaims or claim for multiple conditions. So they might put in a claim for hearing loss and tinnitus and lumbar spondylosis within the one package. And the approach that was undertaken when I was first there, I think, is the sort of the default approach really is to approach that as if it's one claim and to assess it as one package and sort of to deliver all those decisions at one go. Claim splitting is where you say, well, we're going to divide this claim into two completely separate claims that will be processed separately and differently, basically. So instead of having one claim that contains hearing loss, tinnitus, and lumbar spondylosis, you now have two distinct claims that contain, one containing lumbar spondylosis, one containing the hearing claim. The veteran-centric justification for that, the sort of positive justification for it, is that it allows the simpler claim and the one where there's evidence available to get processed so that the veteran doesn't have to wait for a potentially more complex claim to get processed. So in that example, you might not have evidence enough to address the claim for the lower back, say, the lumbar spondylosis, but you do already have a hearing test that might have been done previously, and you've got enough to sort of just process that, determine it, start the process of providing compensation and treatment to the veteran. So if done safely, my view is that that's a reasonable thing to do. But there's another reason for doing it, and that is around the manipulation of time taken to process numbers. And that's because if the claims are sort of processed in parallel, no matter which way you count it, whether or not you sort of, that's my understanding, is the current process is sort of 1 point for one package for the delegates sort of KPI tracking. I think that's a bit unfair on delegates, but a side issue. But it doesn't matter how you count those points, splitting it is a way to reduce your TTP sort of averages, because you can have one that's suddenly processed in 1 day, and if the other, takes another 42 days, you've, halved your average instead of sort of having them both contribute to a high average. And so it's a way to basically game the system and drive down times taken to process.
What's the problem that can arise? So tinnitus may have nothing to do with the left knee problem, but you suggest that sometimes claim splitting is disadvantageous to the veteran,
Absolutely.
even if one is quickly processed.
The problem is it's not uncommon for claims that arrive, conditions that arrive within one claim to be interrelated or interdependent, either in terms of diagnosis and the associated sort of determinations around liability, or in relation to impairment. So the two sort of easy examples, I think, to understand how this works is if you have in the one claim a claim for right knee osteoarthritis and for lower back pain, splitting those for the purpose of IL probably doesn't have that much effect. But at the PI stage, if they're getting assessed at different times, potentially by different assessors, because that's a possibility, that the same veteran might end up having to see 2 orthopaedic surgeons for those 2 different claims, they are actually interdependent to some degree within the actual impairment assessment. And so it causes both unnecessary investigations for veterans, unnecessary time spent in sort of impairment assessment, but also a real confusion and muddying of the waters in terms of impairment, because those physicians that are asked to sort of do the impairment assessment are obliged to provide some kind of apportionment between the percentage of impairment from one or the other. The thread that links those two is that, and the approach that I think should be adopted and was eventually adopted, you apply a lower limb function table to both those in recognition that the back sometimes impacts people's sort of walking distance and other things. And so you've got this sort of interdependence there at the permanent impairment stage, and it really makes things unnecessarily complicated if you split them. That is not a great thing to do, but relatively benign compared to if you split interrelated or interdependent conditions from the perspective of liability. And the example there is if you were to split, say, a claim for, the veteran might put in very specific claims like lumbar spondylosis and intervertebral disc prolapse. Different things, but medically interrelated, and within the statement of principles, they're quite complex to unpack. And sometimes we view that prolapse as part of the degenerative process, which is what lumbar spondylosis is. Sometimes it's a discrete injury that needs to be assessed separately. And those liability determinations are actually interdependent, particularly as defined within the SOPs. And if you split them, that could be an absolute disaster in terms of a mess for the veteran. A worst case scenario, they end up having their entire impairment sort of claim inappropriately reduced to 0 as a result of sort of someone processing the prolapse claim inappropriately, basically. Do you want me to go into the details of why that is?
Got the detail in the statement.
Yeah, okay, so...
The net effect is this, isn't it? Sometimes, especially with interrelated conditions, if the claims are split and go down two different paths at two different speeds, the veteran could end up getting no compensation when he or she would have got compensation had the whole medical situation been assessed in the one process.
Yes.
And is there not another element to this, that by the time the whole of the decision-making has occurred, it's too late to appeal against the original decision that led to the disaster you mentioned?
Most of the time, most of the time the claims get to PI, at least in my view, the recourse to reconsider IL decisions had exhausted, and that the only thing the veteran could do would be put in another claim. And that was based on essentially what delegates would tell me when I would pick up these errors and would say, what can we do to fix this? This is really bad. And the PI delegate would, I think in every case I ever had, would say, well, we can't really do anything except get the veteran to put in a new claim, because that IL decision is made, final and finished, and they haven't appealed it.
Yeah, and from the veteran's point of view, the veteran is told initial liability has been accepted. Seems to be a favourable decision, but in fact it turns out to be a very adverse, in a sense adverse, but it's too late to fix it by the time that it's apparent what disaster has befallen him or her.
Yeah, I think in most cases the veteran would have no idea that had occurred, particularly in sort of more complicated versions of it, like the example I gave. They're not going to know until it's too late, I think. And that was the impression that I got as what had occurred. Otherwise, if the veteran knew, presumably they would have appealed the decision, but I saw plenty where that hadn't happened.
To what extent was claim splitting a deliberate process? You've mentioned the motivation of reducing time taken to process statistics, but to what extent was the department aware of the deleterious effects and consciously deciding to keep going with the splitting?
I think they were aware and consciously decided to keep going, essentially. I mean, I made the department aware of the issue, and at multiple times I made them aware to multiple sort of different levels of leadership. That, to my sort of understanding, had very little impact in terms of their willingness to continue to do it.
All right, I just want to go to one other feature of the way claims were processed, about which the public may not know, and that's called accepting the wrong condition. Could you just tell the commissioners what that is? By all means, use an example if you think that's a good way of illustrating it.
Yeah, and that's just my term for it, to make it sort of simple. Accepting the wrong condition is essentially a tactic used to speed up the processing of claims. And the way it works basically is a veteran puts in a general claim, say for left ankle. Any sort of, I guess, reasonable reading of most of those claims, the veteran would usually have said left ankle, and then in the description of what's wrong, they'd say, I'm having trouble walking, as in, today I'm having trouble walking. The delegate would review sort of historical medical evidence and find, say, a left ankle sprain from some number of years ago that clearly was not an explanation for the current, a diagnosis that adequately explained the current impairment the veteran was experiencing and claiming for, but could arguably legally accept that historical diagnosis rather than engaging in further investigation or asking for more evidence from the veteran. They could do that very quickly. So if you find, in the service medical record, there's a note somewhere that says left ankle sprain, what would happen is they would apply that diagnosis of left ankle sprain, usually with the support of a medical advisor, and separately sort of raised issues about some of the behaviours that were used to extract those opinions from advisors. But essentially, once they've got that medical confirmation that yes, that's an ankle sprain with date X, they will accept that condition as the condition that explains the veteran's claim and send it on to PI. So the veteran gets told, your IL claim's been positive. We've accepted it. We're sending, you just need to go through to claim your PI. I don't necessarily think veterans should be expected to understand that what happens next is going to happen. If you work in the department, you know exactly what's going to happen to that claim, but I don't think anyone outside would necessarily understand it unless they view these things. And what basically happens is at the PI stage, the GP or the specialist or whoever else is asked to assess impairment in relation to left ankle sprain. And they look at this and they say, well, there is no current impairment in relation to left ankle sprain because the diagnosis is left ankle osteoarthritis. I delve in the statement into the details of why that's actually a reasonable opinion to give, and the problem is arising at the IL stage. But what that results in is no impairment points awarded to this condition for the veteran. And again, almost invariably, their chance to appeal or have a review has been exhausted. So their only recourse now is to now claim again for the osteoarthritis that should have been investigated and accepted in the first place. That's it in a nutshell, essentially. It's a pretty horrendous practice.
And so far as you know, to what extent was it the practice of the department to tell the veteran what had happened so that he or she could make an informed decision about lodging a new claim?
To my awareness, there was never any policy that did that, and there was no sort of cultural direction to do that. My, I guess, justification for that perspective is every time I was involved in these, I had to really get involved to solve the situation. Most of the time, when I saw them when I was sort of in the later stint in Perth PI, when I saw those, the delegate didn't actually have any idea that there was an issue. They were just sort of, oh yeah, it's left ankle sprain is accepted. The impairment points are 0, go about day-to-day business. They wouldn't recognise that there was actually a problem there, and I had to alert them to it. And then when I alerted them to that problem, they knew of no mechanism to fix it, no procedures being put in place to address the issue or to have communication between delegates to solve the issue. The only way we ever really fixed them was, medical advisors would sometimes alert each other when they saw these, and then we would trade favours might be the term, or lean on delegates that we had a good relationship with to get that new claim processed same day, if that makes sense. So we would say, all right, we'll get the veteran to put in a new claim for osteoarthritis. We'd talk to the delegate in PI and the advisor in PI. We'd get a friendly IL delegate to say, yeah, I can quickly say yes to that. There's evidence to say yes to it. Often the evidence was there all along, is the other sad thing, is in those cases we didn't necessarily have to go out to sort of seek something else. And so we'd solve it that way, but it was very manual and hands-on. And from my perspective, there was no departmental approach that said, all right, well, we recognise this is a problem and we're going to address it at a system-wide level.
To perhaps briefly to another topic you've raised, which you've labelled duty of care issues.
Yeah.
There was an issue which you felt serious enough to contact your medical insurer about. Could you tell the commissioners what that issue was and the potential impact on veterans?
Yeah, so this was early on. I was sort of told by the CMAs who were working, I guess training me, that part of the job was that you would request X-rays and other imaging, and they had little X-ray books to do this, and you would do that directly. And that sort of struck me as strange because it was very obvious that the department had no process in place for ensuring that those tests got reviewed in a timely fashion. and no processes for ensuring that if something were to come up on that was clinically relevant, that the treating clinician or the veteran would be told about it. And that sort of struck me as a really dangerous situation, both for veterans, but also a real duty of care and medico-legal issue, because the usual practice for any organisation that orders those kind of tests is to have some kind of process in place where you can sort of make sure those results are reviewed and delivered, if they have clinical relevance, are delivered to the treating clinicians. Even the organisations that provide independent medical examinations, my understanding is they have those mechanisms in place in case when they see that X-ray, it shows something that needs immediate attention, which doesn't happen often, but it's certainly not, it's not something you want to muck about with. Probably the most common instance where we did actually see things that needed to be addressed was in hearing tests, where sometimes we'd see a pattern of hearing loss that might indicate a tumour. And that's information that needs to be dealt with properly. But the department just had no mechanisms in place to sort of make sure the tests are reviewed. The other issue is you can't order a test and have it sit there for 3 months. It's not a proper handling of that kind of evidence.
When you say you can't,
well, you can.
You really mean you shouldn't.
You shouldn't, sorry, you shouldn't.
But was it happening?
Of course, it was happening. Because of these queues and there's sort of the chaos of the place, there's no guarantee that evidence is going to get back to an advisor in any sort of specified time frame. I acknowledge that it's possible. I mean, the advice my medico-legal people gave was just don't do it. If you do that,
Don't order the tests.
Yeah, don't do it. If you do that and something is there and you didn't review it in time, you're responsible. You can't do that within an organisation that doesn't have proper processes. Now, I accept there could be an argument to say, because it's medico-legal, because it's for the purpose of claims processes, that potentially legally the department's not obliged to do these things, that they're somehow outside of the purview of those kind of processes. But I think if you look at it from a sort of moral and sort of veteran-centric perspective, I mean, it's very bad to be ordering tests that could potentially show things that the veteran's GP or specialist really needs to know for the care of that veteran, and potentially just have them sit in files for months and nothing happen with them. Regardless of the legal reality of that, I felt it was a pretty terrible way to be approaching this kind of evidence.
One could imagine a system in which whenever such a test was ordered, whether it showed anything that needed attention or not, the results of the test, whatever it was, would just automatically be sent to the treating general practitioner to put on the general practitioner's file, along with everything else that the general practitioner would get from specialists and his or her own observations. Was there any system of that kind?
Not that I'm aware of. Obviously, when we picked up things, we acted on them, and I tried to encourage that sort of policy where if we're going to do this, we need a policy in place, but I'm not aware that anything actually got in place, put in place to deal with that issue. And it was still very much a topic of discussion for advisors when I returned in 2020. That was a real topic of discussion among the advisors, that particularly the hearing test issue. And so as far as I could discern, still nothing had sort of been put in place. And that was despite the department very clearly being alerted to the issue prior.
Was another aspect to this that some tests involve radiation or intrusion and should not be ordered for a non-clinical purpose?
Yeah, I think that that is certainly an element of it as well. I mean, if you don't need to be ordering those tests from a clinical perspective, I think you have to think hard about whether or not the medico-legal side of it really justifies it. And I think the veteran really needs to be well informed about that as to whether or not they're going to accept those risks as part of the medico-legal process. But again, I don't think that communication ever occurred. It was just sort of like you need an X-ray, or you need this particular scan as part of your claims assessment, we're just going to send you for it. There's arguments to say, yeah, you get the X-ray even if it is, for a medico-legal purpose, because the overall risk and exposure is so low. But that's something that has to be happened, in the sort of context of informed consent for the veteran and understanding. And again, I don't, it's not like you would write that X-ray form and call up the veteran and say, we're sending you for an X-ray. This is what it means, and this is why we're doing it.
Last week we heard from one witness, or at least one witness, the suggestion that the department acts like an insurance company, and not a very good one at that. And I apprehended that the witness was saying that the department shouldn't. You've suggested that the department should consider itself in part as a medical organisation that adhered to certain standards of medical practice and governance. Could you explain to the commissioners what you mean by treating the department that way, or it should be treated that way?
Yeah, so I think there's two sides to it, really. One is that the department is currently constructed, I don't think wouldn't be accurately described as a health organisation, not at least in totality. So one side of the perspective is that I think a future direction would be better for the department to be identified as and self-identify as a health organisation. And that's sort of somewhat of a vision for the future of how these things, what should be the centre point of this organisation. It should be health. But there's also another aspect to it, is within the context of the way it currently runs, which is really very claims focused. There is still an enormous volume of health information that the department collects and utilises. Most of the processes in the department, one or another, are dependent on health information. And I think at that scale, and with the health information being so critical to what the department does, it needs to sort of hold itself to some of the same standards that any organisation sort of engaged in health and health information should. So hopefully that clarifies it. Yeah, I think there's...
Thank you. Commissioners, we're about 4 minutes ahead of schedule. Having scraped the surface on claims processing issues and the way it's really done, what I would respectfully propose is that we take the midway break now and come back to talk about the culture of the organisation in looks like an hour.
Yeah, it's actually the lunch break for 1 hour. So if there's no other issues, we'll adjourn for lunch.
Thank you, Commissioners.
The Royal Commission into Defence and Veterans Suicide is now resumed. Please be seated.
Thank you, Mr. Singleton.
Thank you, Commissioners. Dr. Seidel, I just want to ask just a few concluding questions about the matters we canvassed before lunch and then go on to something new, as I predicted. Did the department, so far as you know, conduct any studies or audits or reviews, however named, to determine how often claims splitting was being done appropriately and how often not? Or is your microphone on?
Not to my knowledge.
Thank you. Was there a policy on claims splitting and when it should occur and when it should not occur?
Not a formal one, to my knowledge. We tried to put in place informal measures to stop some of the problems I described at the sort of local level.
Who's the we in that stuff?
I guess myself and other senior advisors in Melbourne, just to stop some of the more egregious things, but I'm not aware of any actual policy that was implemented by the department.
Was there training, as distinct from a policy, but was there training directed at preventing inappropriate splitting?
Not that I'm aware of.
I'll wrap it all up at once, but you tell me if you want to break it up. But I want to ask the same questions about accepting what you've labelled as accepting the wrong claim. Policy or training to stop that?
Not that I'm aware of.
Sorry, it sounds like it. Feel free to elaborate if you want.
The accepting the wrong condition situation, there likely is, it's a grey area as to whether or not that is legally appropriate, and there may well be policies that that's sort of contravening, but I'm not aware of any direct attempts to sort of stop it, except what occurred when we sort of raised the alarm in a particular context in the Melbourne office. I'm not aware of any departmental attempts to sort of stop that happening, and certainly it was still happening after we raised the alarm. You know, it was several years later, it was still happening. At
least at a general level, is it the case that whether or not the right or wrong claim or injury has been accepted or identified is a matter of judgment for both a delegate and a medical advisor? But are you aware of any studies or audits or anything of that kind to determine whether there was a problem, and if so, how big the problem was?
Not really. The only study, I guess, that touched upon it was the medical evidence and medico-legal report that I was a co-lead of, where we did do some audits as sort of whether or not investigations needed to be sought, and that was more focused on sort of medical evidence requirements. But as part of that, if you dug into the detail of those audits, you would find some data around this kind of issue. But I'm not aware of anything else that really looked into it in detail.
I might just divert there and look at, explain what the medico-legal evidence report was. As I understand it, you were part of a team known as OPI, which studied a couple of matters, one of which was this preparation of this report. Just tell us what the document was that you were working towards and finally produced.
Yeah, so it was called the Medical Evidence and Medico-Legal Project, and it was a project with a broad scope, sponsored by the Secretary of Department, with a view to investigating the way DVA was handling medical evidence, sourcing medical evidence, had a sort of a broad purview to look at anything that had anything to do with sort of their handling of medical data, basically.
And in the course of preparing that document, did you, with such assistance as your team provided, look into what was actually happening?
With regards to medical evidence?
Yes.
Yes.
And I won't be comprehensive, but it was an element of the work that you were doing, an examination of what was happening and what should happen with respect to the way medical evidence was assessed, how much was needed, and those sorts of issues?
Yes.
All right. We might come back to it in more detail. The way that claims processing was done in your time, as I understand it, but you correct me if I'm wrong, essentially involved breaking the process up into a series of decisions that were made at different times in sequence, the first one typically being whether or not to accept liability, and at a later stage there would be other decisions such as the level of impairment and what compensation might be due. Correct?
Yes.
And you've described this as akin to a factory production line process. Was that the system when you arrived in 2012?
It was less emphasised, and so there seemed to be a bit more integration in 2012. That system seemed to, or the system in general, seemed to become more fragmented over the next few years. So there seemed to be more inherent capacity when I arrived there for delegates to be able to sort of do both a liability and permanent impairment. Particularly, for example, circa delegates at that time would usually do both. VEA would do both. And then MERCA, there was a bit of a divide there, but there was, I think, a little bit more integration, a little bit more communication as things expanded. The sort of fragmentation and the specialisation of those teams sort of expanded along with it. So I'd say it got less integrated the further we went along after 2012.
I'm not asking for any names or descriptions of people, but was that a process that was either being driven formally from Canberra? Was it being driven from Melbourne? Was it just accidentally occurring and no one was driving it?
I mean, my understanding was it was the realisation of a vision of how claims processing should be undertaken. Now, I might be wrong on that. I had to, put together sort of different sources of evidence, I guess, to come to that understanding. But the understanding I came to over several years that it was a sort of I'm not sure whether coherent vision is actually the right word, but it was a vision of how things should function, driven by leadership from one of the particular locations. I don't know whether I should specify that here or not.
Don't worry about specifying the individual or
Yeah.
the role that he or she played. And I will come back to how you formed these views, but just for ease of presentation, was it your understanding that this process, this tendency towards more fragmentation had begun before you arrived, or did you see that it began after?
It's a long time ago. It's very difficult for me to say with any certainty. I think it had probably begun before I arrived, but certainly accelerated after.
Now, I'm not wanting to put words in your mouth, so I'm just hypothesising some possibilities. The real question is, how did you come to the understanding that that was what was happening and that it was part of a vision or a design? For example, maybe people told you things, maybe you read documents, maybe you just saw it yourself or saw things from which you drew inferences. Could you give us a sense of how you came to the understanding that there was a deliberate movement in this direction?
Yeah. So it is partly based on what people actually said. So the words, the claims process as being described as a factory is not my analogy. That's the analogy that leaders within the department actually described the systems to me when I was having discussions about sort of systems improvements or raising issues. It was described on multiple occasions as it's a factory. That sort of was coherent with my observation of how things ran and how things were being driven to run over time. And then there were other, I guess, points of evidence that I saw as sort of confirming that idea that there might be a vision there. Partly that came out of some of the meetings I was privy to when I did the acting principal medical advisor role and saw some of the interactions between leadership. And that certainly seemed consistent that there was a vision being driven and a certain locus of control for claims processing. I guess there was individuals who had more power there and were driving a certain agenda, I think. And then you can also see the outlines of this sort of vision in something like ISH is probably a good example, which that whole process was really very much reflective of that fragmented idea. And then you can see it in the way that teams were expanded and specialisation sort of started to occur more and more over time. So I can't say someone directly said to me, "This is my vision," and it's that simple. But yeah, I put all that together and thought this looks like someone's vision of how this should run.
So you've, and again, correct me if I'm wrong, I'm just trying to remember from 2 minutes ago, which is not one of my strong points, but you said it was the understanding you formed, and I think you said I might be wrong about whether it's a vision. Is that a qualification you apply to whether it actually happened? So there's a difference between the fact of it happening and whether or not it was a vision. Was that fragmentation actually happening, or is that merely...
The fragmentation itself was very real.
And we understand already that the VEA system is closed but has a long grandfather tail. We understand that the Mercer is the current system for anything that happens today. We won't need to go into the detail of the complexity of the legislation. But I make that prefatory remark because you referred to the fact that the fragmentation was somewhat dependent on the acts. That, and the older acts were not as fragmented as the newer Mercer. Against that background, can you comment on the beneficial aspects and the deleterious aspects of the fragmentation? Is it better to be fragmented, better not to be, and so on?
In my opinion, the fragmentation was mostly harmful. I can see the rationale with complex legislation, and particularly if you're trying to expand delegate teams quickly, I can see that it's easier to train people in one specific component of one act than try and get them across everything. But overall, I think it's a really harmful process, basically. It I think increases the possibility of errors, it increases the possibility of vulnerable veterans not being identified, it increases the possibility that people are sent for unnecessary medical reports, it enables some of the other things I've described here. So, something like accepting the wrong claim I think is much less likely where there's actually integration between those processes. Similarly, sort of problems arising out of claim splitting and things like that are a little bit different if the people responsible for solving those problems are either co-located or the same individual who has to deal with the problem they've just created. When you fragment those kind of systems, I think things basically get worse, and I think things did get worse. One way I would describe it is it was as if the department thought that by fragmenting things they would sort of decrease the interdependence of these processes and you'd be able to have this hyper-specialisation, but I think the actual effect of it is to increase the interdependence. You increase the likelihood that a problem occurring in one area is going to spread throughout the system because when you fragment those kind of systems, you remove all the buffers that would usually exist that allow the system to quickly address problems as they arise. And you have, I guess it's a classic silo effect. It works if you're mass manufacturing computer chips or something, but that's not what this was, obviously.
Earlier today, you, in answer to questions, discussed how claim splitting could lead to a bad outcome when it came to assessing impairment. And by that time, it was too late to fix the initial liability decision, which may have been defective. Would that be an example of what you're now saying about interdependency and how, if it's all done coherently, in effect at one time, you can see the consequences immediately of a bad decision and fix it before it's too late?
Yeah, it's much less likely, I think, to occur, those kind of issues, and the problems are not going to propagate in the same way if those teams are located, if those processes are really separated, and I think it's important to understand how separate the processes were. We're not talking about, sometimes it might be another team in the same office, but quite often it was another team on the other side of the country processing things much, much after the initial sort of liability had been determined. I think that is sort of self-evidently worse and more likely to cause problems than if it's happening in one spot and those errors can be picked up and they can be dealt with within the appeal period and all those kind of things. But also on a human level, I think there's a very distinct difference between teams that sort of engage in these sort of processes together, or individuals who have a view of the entire arc of a process, versus teams that are sort of very, very siloed and don't necessarily even understand the bigger picture that they're a part of.
Both today in our oral discussion and also in your statement, we and you have canvassed a number of problems with the claims processing system as you observed it, such as claim splitting, such as accepting the wrong injury or wrong claim, and other things. But I suggest it's a very complicated system that can't adequately be described in just a couple of hours or even 45 pages.
Yeah.
Could you tell the commissioners, as best you can, to what extent are the problems that we've discussed and that you've put in your statement mere isolated slivers, and to what extent do they give a reasonable portrait of the way the whole system worked, particularly with reference to its impact on veterans?
My view is they give a very reasonable indication of how the system worked, and that's why I've put them in the statement as examples. I think one comment I would make around that is it is not sensible to play whack-a-mole with the kind of discrete bad examples I've used. My view is that and one thing I didn't mention before, but these kind of particularly accepting the wrong condition was something that arose organically at multiple different times. I viewed that happening, so it's not the genius idea of a nefarious delegate who might train a few other delegates to do it. It's something that is an obvious solution for delegates when they're faced with pressure that's all about time taken to process. And so even if you fix that one with a policy or something like that, my view is the system as structured will give rise to these kind of behaviours and problems. And to that extent, I think those kind of examples are reflective of the general tenor of the system.
And just fixing the ones that we've mentioned won't fix the system overall?
No.
All right. I want to change direction a little bit, but with this segue, you raised these issues over the years you were there in various ways, is that right?
I did.
One example was that you sent an email in late 2017 to the then Chief Operating Officer to draw attention to some of these issues.
I did.
Among other things, you annexed a couple of documents that you had written that described some of the issues as you saw them.
I did.
But you also raised them in your workplace, in meetings and on other occasions, is that right?
I did whenever I had the chance.
So what I want to do is just get a sense of the response you got and how you and others who might have been expressing similar views were treated. I'm going to go through a series of more specific examples, but before doing that, would you tell us in an overview way what responses you got, how you were treated in the office, for good and bad?
Sorry, I just have to sort of structure that. I guess I'll separate that into the local office and sort of the more departmental response. The departmental response, I know that they sort of initiated what they termed health checks as a result. of some of what I'd suggested, although I got the impression maybe that was in the pipeline already anyway. In terms of specific things that were mentioned there, I didn't see much response in the time I was there. In terms of the local sort of environment, to be honest, by the time I put those concerns in writing, it was an untenable place for me to work. And if it weren't for sort of being offered the position with OPI and trusting the leaders of that team, I would have left the department after the acting principal medical advisor role, because it was just not a tenable situation to stay in the Melbourne office for me. And that was because my efforts, I guess, had started to create an environment where the leaders there were very much not happy with me. Some of that was put more sort of overtly to me than others.
You mentioned health checks. Let me clarify that. Was that a health check in respect of your health or the
No,
department's health
some
or
kind
the
of broad
system's health?
departmental cultural health check. I'm still, I gave evidence to it, but I'm still somewhat vague on exactly its terms of reference were. But it was the idea that this sort of investigator was going through the department and gathering accounts from individuals about cultural issues, and that would be used to drive change in some way.
Were you and other staff who took a veteran-centric approach subjected to certain labels?
Yes, the one I mentioned, or the example that sticks clearest in my mind is that we were labelled Care Bears.
Were other disparaging remarks made about people who were within the department, and I include contractors, who were trying to advocate for veteran-centric approaches?
Yes.
What about comments about veterans?
Yes. I want to frame this by saying these sort of things were largely the exception. So I don't want to cast this as every delegate would say these kind of things. And I also want to frame this in that I don't necessarily, some of these comments came from ignorance more than they came from, I guess, cynicism. But there were certainly delegates and leaders who made disparaging comments about veterans, who were very inherently cynical about veterans' claims and their right to claim. I don't know if you want me to go into the specifics of those sort of comments or not.
Don't want any individual
No,
people named.
It's not.
In one of the documents you submitted to the former COO, you said that there was a general culture of cynicism and distrust towards veterans and claims propagated by from a certain quarter.
Yep.
To what extent was that a reflection just of that? Does that mean the general cynicism of the person or persons propagating it, or the team, or
yeah, that references, I think that appears in reference to a specific team, that leaders were sort of spreading that sense of cynicism from within that team and to without it. I think the clearest way to put it is most of the cynicism came from leaders. So that occurred within multiple different teams. There was one where it was particularly bad. And that would form sometimes the part of the training, if you like, of delegates, to be sort of cynical and sceptical about claims. I'm sorry, I don't have those documents in front of me.
No, that's
so
all right.
Yeah.
Now, you've referred to leaders, and we should be, it is in evidence in writing, but I think it's fair to identify the level. You're not talking about the secretary or the deputy secretary on this occasion. You're looking at roughly the so-called assistant director level, that sort of level.
We're looking at APS 6, EL1 and EL2 level. Mostly EL1 would be the issue, but
Coming from that approximate level, were clinical advisors told that they advocated too strongly for veterans?
yes,
How often, or in what context?
relatively frequently if we presented opinions that the delegate or the team leader wasn't happy with because it didn't correlate with their vision of how that particular claim was going to turn out.
You write that one person went out of his or her way to belittle and professionally insult advisors who argued for veteran-centric outcomes. Can you give us a sense, as long as you don't identify who was saying it, a sense of what kind of belittling and insult might be, how it was expressed?
Well, the most obvious one is the example I gave before, labelling those advisors as care bears, and it wasn't it was very clearly a pejorative term, and that's in the context of professional meetings. Making comments about sort of the approach to that effect, maybe not always the care bear comment, but comments along those lines in professional meetings where there were other delegates present, and basically saying that the doctors were being sort of too lenient or too compassionate, or whatever it might be. My strong view on that was I never actually went outside the bounds of what was in the evidence. So I wasn't sort of making extraordinary suggestions. If a claim clearly could not succeed on its merit, I wasn't there suggesting that it should. These are instances where we were suggesting that the medical evidence strongly supports the claim, but that was met with significant resistance among some of the leaders.
You wrote that one leader at the level we're discussing spoke of scope to reject rather than scope to accept. Could you just explain what that means and give us an example of how it would work from an evidentiary point of view?
So I guess the way that the legislation I think probably should be interpreted is that you view the evidence through the lens of, is there enough here to accept? Obviously there's sort of reasonable boundaries around that, but if there's an opening to accept, and this is sort of enshrined somewhat in the statement of principles as well, if those factors are met, or one of the factors are met, there's scope to accept. That probably should happen. Scope to reject is actively looking for sort of minor discrepancies in that evidence or technicalities, and then using that as an excuse to reject, where otherwise, the evidence would suggest it should be an accept.
To what extent was that just a matter of trying to undertake a fair reading of the evidence and reach the proper conclusion, applying the statutory test, whether it was the plausibility test or the balance of probabilities, and to what extent was it, so far as you could see, a bias to try to reach an adverse outcome?
My view is that it was more driven by bias rather than a sort of sense of due process. Now, there could be, definitely about some of those cases, sort of, I'm not a lawyer, so there could be argument about the meaning of balance of probabilities applied to these situations and what evidence is required. My distinct impression looking at a volume of cases and being involved with those decisions was that there was a definite sort of inherent bias for some of these team members. And again, some of that seemed to come from a sort of what I described as a culture of burnout, where a more experienced advisor had either burnt out themselves, or maybe they'd been taught to behave in a burnt out way, I guess. But what I saw was that leaders who'd become burnt out would then teach the delegates, younger delegates who weren't yet, I think, actually burnt out, how to behave in burnt out ways. They would teach cynicism and skepticism and apathy. And I guess a compassionate reading is that what was going on there was that some of these people who appeared to have a bias against veterans had actually sort of burnt out in the process of doing this work, or for circumstances in their personal life or whatever, and were now sort of bringing to bear on this process this apathy and cynicism, and that it wasn't, necessarily a core moral failing of theirs, but something had gone wrong. But then I could observe that being replicated for new staff members who were just coming to it afresh. Hopefully that answers.
Yes.
that,
Now, correct me if I paraphrase you wrongly,
Yeah.
but to the extent that you have said that there was sometimes an approach of scrutinising the available evidence, looking for the bits that were adverse to the claim and relying on them, how did you actually see that that was occurring? Was it, for example, bearing in mind you can't read another person's mind, was it a matter of discussion? Was it written down?
So I won't give the exact example that illustrates this best because it could identify the claim, but the clearest example to understand these kind of discussions was a rather extraordinary one that centred around the grammar essentially around grammar that a veteran had used in a claim, and that a really sort of a slither of a sense that maybe there was a secondary interpretation that the person was not claiming what a normal reading of their contention would be. That very thin slither was used to open up this sort of scope to reject, where and this occurred in the context of a team meeting with multiple people reading these documents, saying like it's pretty obvious what has been claimed here, and yes, the grammar is not perfect. There is arguably some ambiguity, but it's not the kind of ambiguity in context that we would use to sort of open up the can of worms and, for instance, ask that veteran to restate their contention, which included the recounting of traumatic experiences. So that's the sort of, I hope that answers it, but that's the sort of way in which that would occur. You'd find that they might find little discrepancies and open them up, but the most sort of banal version was, in one instance, it just came down to sort of a grammatical interpretation.
So that's a specific example of how, in my paraphrase, a nitpicking approach could be used to the disadvantage of the veteran. But my question was a bit different.
Oh,
I
sorry.
think you did answer it,
Okay.
but I'll make sure I understood properly by
Yeah.
putting it this way. On that occasion, you understood that the nitpicking approach was occurring because you heard the relevant DVA staff member saying it
Yes,
in a meeting.
we had the debate, yes.
Yeah, and is that just a one-off, or is that the sort of way that, insofar as you've made general comments about what I'll call a scope to reject approach, is it based on actually hearing DVA staff saying things like that?
Yes, and then the mechanisms of that also being enacted, obviously, like knowing that things were rejected.
Right, so you also saw that the decision did
Yeah, yes,
follow.
seeing the follow-through of those decisions, yeah.
Right. Well, I want to just go to just a couple more of examples of how the attitude actually applied to claims, no particular claims, of course.
Of course, yeah.
Could I just ask you to turn your thoughts to the way sexual assault and indeed other assault claims were treated, and whether there was a proper modern understanding of evidence related to such allegations?
This is one of the aspects that really first alerted me to the fact that there might be very, very serious issues at the department, was really not just the processes, but overhearing the way in which some of these claims would be discussed. It wasn't uncommon to hear people sort of make comments along the lines of, that person couldn't have been sexually assaulted because the person who sexually assaulted them was their husband or someone they had previously had a sexual relationship with. Comments about people couldn't have PTSD because they weren't behaving as if they had PTSD, or they'd gone on to have a good career and now they were claiming they had PTSD and that those things were incompatible. there seemed to be, and this is why I mentioned ignorance before, I mean, that to me didn't seem to be the result of, any moral failing as so much as the people who were making these decisions and viewing these claims just had no understanding of how these things manifest in the real world, had not ever necessarily been in a position where they would have, as most doctors, you meet people who've, described these events to you, and you very quickly, I think most doctors gain an understanding that none of this ever presents in one singular way. It's not what you might imagine in the abstract. You can't tell that someone's got PTSD by looking at them or seeing what their career's been like. And, sexual assault is not confined to, what you might see on a TV show or something like that. But unfortunately, that was the sort of level of ignorance that I was viewing, and that had a very real impact on the way that these claims were approached, because obviously if you're viewing the evidence through the lens of, oh, this person's not behaving as I would expect a sexual assault victim to act, you're going to see the evidence in a very different way than if you're open to the possibility that we can't predict how someone who's been sexually assaulted or has PTSD is going to act in their future life.
Just turn to a broader look at the culture. You have said in your statement that, at least in your time there, the DVA was best understood from a cultural perspective as a series of interdependent fiefdoms. We've touched on a little bit of this before the lunch break, but could you just introduce the commissioners to the concept that you have here and why that's a good way to understand the culture of the DVA and how it works?
Yeah, so my sense was that each of the locations sort of had a primary leader, and they had a control over their particular location. And the default mode was that each of the locations, at least within claims processing, were essentially in competition through comments made by those leaders and the extreme difficulty in getting them to cooperate. I sort of gathered that they were not exactly working together to make things better. And then you could see strategic moves on each of their parts. I described this sort of Melbourne consolidation. You could see this sort of scramble for resources. There were sort of trading and loaning of advisors, but that all occurred in a way that made me form the view that the way to understand this was sort of fiefdoms, that the people in charge of each local area had an extreme amount of control over that particular area, and then they were sort of in competition for resources with the other areas. And the other way, I think, the other reason I came to that view was also sort of interacting with the executive and seeing how different executives interacted, and that sort of lack of collaboration, a sense that if something had gone wrong, it was always, if something went wrong in an IL team in one location, if something went wrong in a claim and it involved problems in both IL and PI, or the IL would say it was the PI's fault, the PI would say it was the IL's fault, and it would be, that would be fairly location specific. So I formed the view that I'm not saying it's literally fiefdoms, but you could understand it via that lens.
You write that internal politics rather than veteran outcomes drove a lot of departmental decisions. Could you give us your take on the internal politics of the department, what it was like, and what effect it had on the work of the department?
It was incredibly dense, was my view, that I'd never experienced anything like it really. Office politics, but also sort of, departmental politics really seemed to dominate how things practically occurred. It is hard to give sort of concrete examples without going a very deep dive into that sort of political environment, but one example I think that is easy to comprehend is something like Ish, and the way that there was a sort of a negotiation to control that largely out of Melbourne, And then as part of that process, some of the other processing areas got sidelined in their influence over the development of implementation of a system that was actually a departmental system. It wasn't owned by Melbourne, but that was certainly how that process sort of started to proceed. So you could see the sort of outlines of those politics in almost everything. Unfortunately, it's very hard to sort of be specific about it without, I say, going very deep into it all. I'm just trying. If another example comes back, I'll let you know.
That's fine.
An easy one.
You've kindly offered to write a supplementary statement,
Okay.
so maybe we'll take you up on that. Let me move to the question of legislative reform. You, at a couple of points in your statement, say you would welcome simplification and harmonisation. My words, but your sentiment. But you have something to say about whether that's the key issue. I'll try and put it neutrally, but what's your view on legislative reform and waiting for it?
So I think legislative reform is necessary and important, and will be a big step in improving things if it's done right. But I don't think it's a reasonable justification to not sort of engage in reforms within the current state of things. And I think the importance of legislative sort of complexity was at times overstated, or often overstated within DVA. Particularly, again, this has implications for IT systems, where there really is this view, and was this view, that we need to wait for the legislation to be solidified. My view is most of the IT systems that you would need, say for medical evidence handling, are legislation neutral and need to be adaptable to whatever future changes might happen. It would be a bit silly, I think, given that there's a whole policy overlay that goes along with whatever legislation sort of happens, and those policies are prone to change, and then there's an overlay of medical sort of interpretation, and that always changes. I don't necessarily see, and I didn't see then, the connection between, we've got to wait for the legislation to change before we can start building the infrastructure that's going to allow us to function better as a department. Because my view, and I'm not an IT expert, but my view is that that sort of foundational IT needs to actually be legislation neutral, otherwise we'll end up in the same mess in the future.
And how did you get the view that there was an attitude of we must wait until the legislation is stable?
Multiple meetings where the reason for not enacting certain changes was it's all too complex legislatively. And then the sort of corollary of that, of there being this huge emphasis and a lot of discussions you'd have with people about what we might change and how we might do things better, even at the detail of sort of reintegrating claims processing as well, that there's too much complexity. We can't have these teams integrated because these three acts are just too difficult to deal with. It was a real central topic of conversation, even when it didn't need to be, was my view.
Let me have a look at two of the things you did when you were at OPI. One was the Special Operations Forces pilot. Could you just summarise just what that project was and what your role in it was?
Yeah, so this was a pilot, I think, envisioned by Major General Jeff Sengelman to try out different ways of doing things using the Special Operations Forces as the sort of test case. I think selected as a group of individuals who both had a higher sort of burden of trauma and injury, but I think also from a politics perspective, not a group of people that the department or defence were going to argue about devoting some extra resources to run the pilot. I think the easiest way to actually understand the pilot is to see it as, I think, the only example where someone has looked at the situation and said, we're trying to be veteran-centric, why don't we just literally be veteran-centric? So most of veteran-centric reform was, how do we be more veteran-centric in our claims processing, or how do we be more veteran-centric in this sub-process and how we get information in? But I think what the soft pilot was really about was saying, why don't we just literally centre all the things that need to be done literally around the veteran in real time? And so there was on-base assistance with sort of getting all the information needed for claims and ready at the point of discharge. There was on-base assistance with a case manager who was skilled in dealing with any of the sort of mental health and social issues that might arise. But it was also deeply interconnected with the team handling the claims, so they could feed back, hey, the claims are going to be complex, therefore the case manager could sort of help manage that additional complexity. And then there was a dedicated team in Sydney with delegates and medical advisors attached to process the claims as quickly as possible to try and get IL, so initial liability, permanent impairment and incapacity payments, all those claims basically done all at once, working as a multidisciplinary team. And then you had some stopgaps as well. For instance, I was attached in that role as a senior medical advisor, so there was a policy we had in place that if any of these claims were going to be rejected, that they would be escalated to me for review of the medical evidence to ensure we hadn't missed anything before that actually occurred. And similarly, I was there to sort of take any escalations of any issues that any of the team members had that related to sort of medical evidence and how we could navigate things. And sometimes also just, you know, I'm not an expert in sort of dealing with welfare issues in that context, but sometimes was asked to just give my opinion, how do we navigate this, who we should, you know, what services should we make sure the veteran is linked into, because we've identified a vulnerability. That was the setup, and in my view it was, you know, I think objectively a success in terms of the ability to move through the processes quickly and the sort of the satisfaction of veterans engaging with that team.
It sounds like was quite a different approach to claims processing in that it wasn't the factory process of one step in one place at one time and then at a later date another step was taken and so on. But I think you said it was all dealt with roughly together.
Yeah.
Is that a fair way to understand it, and is it fair to so you've nodded to that bit?
Yes.
Yeah. To what extent did it appear that it would overcome the problems that arise from inappropriate claim splitting or accepting the wrong injury or claim and other issues?
I think it sort of completely overcame a lot of those issues because it is, what it does, in my view, is introduce these inherent buffers in the system. So it gives each operator who's got a different role within the processes a chance to see what's going on in other processes, and it provides this really strong buffer against complexity in one part of the process or complexity in the veteran's life sort of spreading to other processes. You can actually actively engage and say, you know, for instance, hang on, this veteran can't get their specialist reports done right now for whatever reason. You know, there might be a complex social situation that means they can't quite do that. In a normal environment, that becomes sort of very difficult for the veteran to deal with. They've got DVA saying, oh, we need your claims by date X or your evidence by date X, but they're unable to do it. In this kind of situation, you've got this inbuilt buffer where the team has a simple case conference, and when we go through the list and say, you know, this particular person, actually we're going to have to just put a pause on this particular subset of processes because there's an issue in the social situation which is preventing us proceed. We can pause that and then come back to it. That's just one example. You know, it happens in the inverse as well. It prevents claims complexity. So We might say, hang on, this claim is actually complex. We're going to have to line up some, this veteran might just need to see a different kind of specialist to understand, is this the right diagnosis? You prevent that situation sort of spilling into their, social and mental well-being, because you've got a case manager there who can explain the process and can provide that buffer against it becoming a situation where the veteran doesn't know what's going on, or is being sent for reports and they don't know why. All those kind of things, I think, get solved when you actually have an integrated team doing this kind of work. There are only just a few of the sort of examples you'd see of preventing risk, basically. Things like claim splitting. I mean, if you're getting the time stake in a process that you get out of doing it that way, then claim splitting is not a sensible option, really. It's not necessary, either from the perspective of veteran sort of outcomes or from the perspective of gaming the system. And accepting the wrong condition is also not something that anyone in that situation is going to do, because it's going to be immediately picked up by the other team members. Hey, this veteran's claimed left ankle, and you're accepting left ankle sprain. That's clearly not what is actually going on here. We know they've got a diagnosis of osteoarthritis, or that's more likely. That kind of thing just can't happen when it's an integrated team. I mean, I guess it could, but the whole team would have to go off the rails a bit.
But the difference being that with the sprained ankle, if it gets accepted under the current system, or the one you worked in Melbourne, except the sprained ankle, by the time somebody else recognises it's a case of osteoporosis, months or longer later at the impairment stage, it's too late to fix the original acceptance of the claim. But with your integrated approach, both parts of this process are being dealt with at the same time, so the problem is fixed immediately. Is that a
fix immediately, or just never. It's not a strategy that people who are genuinely. It's a strategy that's either employed by people who don't know what they're doing, so delegates who've just been trained to do that and they don't understand that it's really bad for veterans. Otherwise, it's not employed by people basically who understand the implication of it and have the veteran's best interests in mind. And so in a team like the SOF team, where part of that was also a cultural view, where you've got people there who are sort of really dedicated to doing a good job and assessing things fairly and doing the job right, basically. But you've also got a sort of underpinning and a leadership structure there that supports that way of doing things. It's just sort of not a likely outcome that someone decides that I'm going to cut some corners in that way. Yeah.
You did mention that Special Forces might have been a special case because nobody would deny them the extra resources that were needed. To what extent were extra resources needed?
Yeah, so I think this is a point of some debate. If you look at the team itself, you can see that it's a relatively resource-heavy team. There's a couple of things about that, though. I think, I maintain that it probably is overall just more efficient. And that's because you remove all these sort of errors that actually decrease efficiency. And one of the things that I think the department doesn't really measure, or didn't at that time, and when they're looking at, and to be honest, I think it was just back of the envelope calculations that the soft model was too expensive, was what does it actually save in terms of the errors and the extra work that is generated from the sort of the fragmentation of processes. I don't think that was ever taken into account. So my view is that, if you are to, you might be able to do a relatively linear sort of scale of that model, just duplicate it. But also scaling it does not necessarily mean duplicating it exactly, if that's where you were going with that question.
I wasn't going anywhere yet, but you mentioned a resource-intensive team. But so, am I right in summarising what you've just said in this way? Prima facie, more resources were needed, but there were savings down the track, which to some extent offset Is that, so far, is that?
I think they would. And there was also certain special things in a pilot environment that were going on there. Like you had a senior medical advisor attached. That's a specific component for both the group of veterans we were working with and running a pilot, because you've got other things going on during that pilot. You need experienced people to sort of have an overview. If you're sort of looking at what were the actual resources required, you sort of have to discount some of those special additions. One of them would be the senior medical advisor. You don't need to be paying me to be available for every sort of claim in a normal environment, as long as you've got adequate escalation processes. But in that environment, it made a lot of sense.
So if it were replicated with adaptation across the system more widely, you wouldn't need a senior medical advisor for every team. You could get away with a CMA.
Not for every team. And the other thing is, I guess part of all this is about what do you learn from the soft pilot, and how would you actually implement it? And one thing I'd sort of suggest is that if lessons from the soft pilot have been learnt, you should be able to go into DVA right now and see a team operating exactly as that one was functioning. And the soft team is sort of, if you went to an alternative universe where the DVA was functioning very, very well, and you took out the sort of team that worked with the group of veterans that had the highest needs, it would probably look a lot like the soft pilot team. So one test is, has that been learned, is, well, there should at least be one team, at least in the DVA, that still functions that way, because it clearly works for veterans who need a bit more sort of involvement. But if you were looking at scaling it sort of out through the department, there's various other things that would need to be taken into account when you think about the cost. For example, even within that team, there was still a sort of disintegration of the processes. So there's still a degree to which there's separate people attending to different parts of the claim. There was an attempt to sort of integrate as much as possible, but if you can actually build the IT infrastructure, the training to truly sort of have one, say it's Merca, you have one delegate doing ILPA, PI and INCAP, well, the scaling cost of that pilot suddenly drastically reduces. So I'm not sure that, I guess in what I've said in the statement is, yes, it's true that you can't just apply, you can't just take that pilot and just apply it to the rest of the DVA. But that's not because you can't practically do it in terms of the resources available. It's because if you don't change your IT systems, if you don't upskill your delegates and support them, if you don't have a vision that sort of actually creates a core identity for how the department functions, and that was a big thing about the pilot. There was an identity for the people in that pilot and a sense of shared values about what we were doing and why we were doing it. Yes, if the rest of the department doesn't share that, it's going to be a very difficult job, but I would argue they were the right values, and the IT systems and all that kind of stuff that you need to support it, well, are necessary regardless of what you do.
You said that if one went to the alternative universe, one would find at least one team dealing with matters in the way the soft pilot team did, and that team would be the one that was dealing with highly complicated cases. Was there something about the way the soft team was working that meant that it was only feasible or practicable for complicated cases and it wouldn't work for easier cases?
No, work for simple cases just as well as complex cases. I think the point there is that you can probably design systems that are sort of a downscaled version, if you like, of the soft model that reflect how that system worked without necessarily having all the personnel involved. So one example is the soft pilot is a good example of sort of verifying evidence at the source. Getting the evidence up front and not having too much of a throw that in the medical advisor queue and wait to see what happens. But if you're systematising that across the department and if you were learning the lessons from it, you'd say, well, a high priority for the department is to ensure that we are sort of externalising the verification of evidence as much as possible. That's sort of the correlation of it, if you like. So in that alternative universe, presumably the department would be able to, for most evidence, not have to have a medical advisor review it, but would have these structures in place that if complexity was identified, it starts to get escalated to sort of more direct involvement of these larger multidisciplinary teams. I guess not dissimilar to what happens in some areas of clinical medicine, I guess.
Was any measurement done of how quickly the soft pilot was able to fully process and determine claims?
Yes,
specifically?
but without, I can't give you the numbers because I'm not privy to the final report since I left.
Did you have
It was
any
quick. It was quicker than, it was quick, basically. Yeah.
quicker? But
Quicker, yeah.
Any sense of how much quicker?
A lot quicker, but yeah, particularly if you measure end to end. But unfortunately, I just can't.
That's all right.
Yeah, because I don't have the number to hand. I don't want to.
I'm only asking for what you know.
As you know, my understanding at the time was we were doing it a lot quicker.
All right.
Yeah.
Were you involved in any way in the decision making that followed the soft pilot with reference to whether it should be rolled out or adapted to other areas or anything like, or continued, and include in your answer whether you heard about what decisions were being made?
Yeah, so somewhat. There are others, obviously, who are much better placed to answer that question in detail. But what I heard and some of the meetings I was part of was essentially there was and even before we sort of started the pilot, so in the preliminary discussions around it, the viewpoint was, no, that's just too expensive. And it's, you know, I guess the view was you're sort of cheating. Of course you're going to have good results if you just throw lots of resources at the problem like that, but that will never work for the rest of the department. That was the view beforehand, and as far as I can ascertain, and from the meetings I was participating as we got towards the end, that view didn't change as a result of the pilot.
That view before the pilot, that it'll never work at a practical level, it's cheating too much resources, if accepted, would have led to no pilot. But apparently that view wasn't accepted because there was a pilot. Was that a view being expressed by the secretary of the day that it was never going to work?
Oh,
Was
no.
it a view coming from somewhere? I'm not asking for names, but
Yeah, of course.
from what direction or what level of the organisation were you hearing that it can't work except through cheating?
In my interactions, the secretary of the day was really supportive. No, those views were coming out of the fiefdoms, basically. So those views were separately put forward by people and leaders in all of the main processing locations, from the sort of EL1 up to the DC level, to sort of say that no, that's just not possible. And that was the view that got put back to the more senior executive, that that's all well and good, but we're not going to be able to do that. As I say, those, you know, I was privy to some of those discussions and have heard some of that from the other team members. There are others who are much better placed to give you the specifics of that.
Sure. Now, correct if I'm wrong, but it would appear that EL1 to DC level didn't change their mind, and after the soft pilot, they spoke against rolling it out. Firstly, is that correct?
I believe so. So unfortunately, this was sort of, as the soft was rolling out, was also when I started to wind up my time during that stint. So there were meetings definitely while we were deep into the soft pilot, and that those were the views expressed. And then my understanding from the people who sort of tried to pitch, the scaling, which were other team members.
Tried to ditch the scaling?
Pitch. So the other team members who tried to say, look, we can scale this, they met that resistance. So I can't speak to the very final meetings because I wasn't necessarily there, but all the meetings that I had prior and during the soft pilot that were around the possibility of scaling this model had the same consistent message, which was this is just, it's sort of fantasy land stuff. It's never going to work. And that was the message that was sort of also put through in those kind of forums and meetings where executives at the upper level were present too.
The view of those who actually ran the soft pilot, however, was that it was scalable with adaptation.
Yes.
Perhaps I could go to the MEML.
Yes.
The you tell me again.
The Medical Evidence and Medico-Legal Project.
Thank you. What was that project and what did it produce?
So it produced a report, and as I said earlier, that the aim was really to examine all facets of medical evidence handling, medical legal reports at DVA. So we looked at everything from sort of clinical governance of advisors and quality control with advisors, to the procurement of independent medical examinations, to systems that we use to handle, to store medical information and to access it. We had a pretty broad purview to look at anything that touched medical evidence, basically.
Did you reach any conclusions about whether or not written in the report, but about improvements that could be made to the way the department dealt with medical evidence, or indeed other improvements that could be made?
We did. I would have to see the document to give you the specific recommendations that we arrived on and the wording, but the general gist of our conclusion was that the entire space was a mess, that there was nothing we identified where we could say that's being done really well. And we identified, as others have, really significant deficiencies in the IT systems that are used to handle medical evidence. We identified serious sort of deficiencies in the way that medical evidence is procured, both from the perspective of requesting unnecessary reports. So some of the work we did was another senior medical advisor did an audit, independent of me, to sort of assess in their expert opinion what was the rate of sort of unnecessary reports. Now, I can't remember the numbers, I don't have the report, but there was a significant amount to which we'd say, well, you don't really need to be, requesting all these IMEs. We identified clinical governance as a serious issue. Despite the best efforts of Dr. Ian Gardner, because of the business structures and the fact that at that time the principal medical advisor was the senior most doctor, there was no chief, and I guess this is maybe a side, but an extraordinary point. When we did that report, there was no chief health officer for the department. There was just a head advisor, which is a very different role essentially. So we identified that as a serious gap, and the fact that there was no clinical governance, and we identified the fact that the advisors were sort of locally owned and controlled rather than being seen as a departmental-wide resource as a serious problem as well. Because the loaning of advisors sort of cut both ways. If one team had got a lot of advisors, it would make sense that it would be easy for another team to access those resources if required, and that would be seen at a national scale. If we have a gap in PI processing team capacity, and that needs to be filled with the addition of medical advisors, there should be a reasonably easy decision for someone at a national level to make. It shouldn't be a trade and a sort of a negotiation between those two processing teams owning that departmental resource as to whether or not it can be loaned, which is sort of how we were seen and referred to. So we identified that as a sort of a serious issue as well. That our view is that you need to view this contracted workforce as a national resource that's governed sort of nationally with someone who's actually a doctor governing it. And you need to have it as a capability that all of DVA can access when they need it, rather than sort of advisors being hoarded by specific teams and other teams sort of suffering and struggling to get enough medical advisors. And the issue there is, or the upshot of all is you can work remotely doing a lot of this medical advisor work. Some of it is good to have co-location, but it's perfectly okay to do a lot of it remotely. But some locations are harder to bring doctors into than others. So it might be easy to find 10 new doctors in Melbourne. It might be near impossible to find 10 new doctors in Perth. But Perth might need just as many doctors in terms of their access. So they were the sort of broad things that we identified.
There is now a chief health officer or chief medical officer. I'm not
There is.
not sure of the title, but do you otherwise know to what extent the Memel report recommendations were implemented?
As far as I'm aware, that was the only one that was implemented in the sort of sense that we sought it to be implemented. And I'm not sure how I didn't get a good view when I went back as to how that was structured and whether or not there really had been much change. My impression that it was that I was still sort of locally owned essentially, but this time by the Perth team. So I'm not sure whether that aspect of it to really try and utilise the advisors as a national departmental resource happened, but certainly a chief health officer was sort of appointed and a deputy chief who has clinical governance responsibilities over the advisors.
I just want to come back to the SOF pilot briefly,
Sure.
because I forgot to ask you something.
Mm.
Essentially, it is, what does the failure of the department to replicate it as much as the soft team felt was appropriate say about the department's culture and management?
That's a very big question. I think there's a few aspects to it. I think primarily it actually just speaks to them not having a good grasp on sort of claims processing and the importance of it and how it really works. That was a consistent theme that I was always sort of surprised by the lack of sort of detailed understanding. If you were speaking to the upper executives in IBM or something, you'd expect a pretty detailed understanding of chip manufacture, not necessarily the real micro details or intel, sorry, but you'd expect to be able to have pretty intelligent discussions. And I just found that wasn't the case. There was a sort of a lack of understanding of the kind of systems that were used and the way that those processes actually occurred. So I think part of the lack of sort of being able to scale it is that lack of understanding, but it also points to this idea that there is a concentration of power in the department at the sort of EL1, EL2 and DC level, and it's not a sort of absolute power, but in terms of obstruction of change and getting what they want in terms of how claims processing is done, my view is they had more power than the secretary to actually do that. It's very difficult for a secretary or a chief operating officer to go and argue with people who are leading the claims processing staff and say, well, no, we think we can scale this. There's a sort of asymmetry of understanding of the issues, and it's very easy for someone who's sort of been doing that for 20 years to overcome any argument someone who's had no sort of real experience of the area is going to put forward, which doesn't mean that the arguments that we use to sort of say we can't do soft pilot were good ones. It's much easier to debate if you really know the issues. But that was my view. That was basically, it reflects this sort of culture where people who don't want things to change have an inordinate amount of power, and it's very difficult. I wish the leadership had been able to achieve it, but I don't sort of look at them and say that was an easy task, or that they faced serious obstruction in scaling something like that. But
So far, I've skipped over the several pages you wrote about a culture of excellence and why it's needed. It's a slogan that's often bandied around, but your statement put a bit of meaning into it, could you just summarise for us what you mean by a culture of excellence and why it would be particularly relevant to the DVA?
Yeah, so in the simplest terms, my definition of culture of excellence at core is, I use a different term here, but I personally think of it as ruthless self-reflection, this willingness to sort of very look at your own behaviour and your own performance in a very dispassionate way and look at all the warts. Coupled with relentless optimism, the notion that whatever you see there is going to drive improvement, that your spirit is not going to be wavered by the fact that you see that you haven't sort of, that there are things you can improve on. And I think you need a balance of both in order to have a culture of excellence. So, you know, doctors, a lot of the doctors I trained, they had sort of too much of the self-reflection and not enough of the relentless optimism. So they'd get lost in, oh, I've made a mistake. And then sometimes the department maybe had too much of this sort of what becomes a sort of form of denial, where they're not self-reflecting enough. They're like, it'll, you know, the sort of she'll be right attitude. You need a balance of both, in my opinion, in order to really achieve excellence. Obviously, there's other things in there, and there's experts on organisational design will have other views, I'm sure. In terms of why, however you define it, you have to have a department that's really invested in excellence. It's simply that you're dealing with a population that we know has inherent vulnerabilities, and that really comes back to the core purpose of this Royal Commission. You know, it's not that every veteran suffers or has a bad life after service, obviously, but we know there's an increased risk. And I think when you know that, and you know that some of the processes that the department undertakes can make life worse for veterans, you're duty-bound and obligated when you do that work to approach it with a standard and a culture of excellence. That's my justification for it. I don't think, you know, the other way to think of it is if you approach it with mediocrity or without that sort of real attention to detail and continuous improvement, it's inevitable that you're going to cause suffering. That's not true for all organisations, but it is true when you're an organisation that is directly involved with a population that has inherent vulnerabilities to things like mental health problems and physical health problems.
You've, in your statement, urged this commission to judge the department by its outcomes, not its aspirations. And whilst that might be a good thing to say about anywhere, you had a particular point to make about why it was applicable to the DVA.
Yeah, this is just one in a long line of reviews and in inquiries. And I think the department, I don't want to be pithy here, but I think if there is something that they did excellently, it was sort of responding to these reviews without actually meaningfully adopting the changes that were suggested. And so I'm personally at the point in my view of the department that I would need to see really extraordinary sort of evidence that things are actually changing and have changed, and I want to see better outcomes before I would sort of reinvigorate my hope that the department can fix itself or right its direction. That wouldn't have been true, a decade ago, at least for me. But over that process of seeing time and time again, the department either asks for a review or has one forced upon it, and boxes are ticked, you start to become a bit cynical about the ticking of the boxes, and start to, in the end, say, this is a complex system, and unless it's actually delivering the results that we need and want to see, we need to not necessarily trust that all these sort of changes are actually working or being applied in the way that they were meant to be applied, or the way the sort of people who made those suggestions intended them to be. So I guess that's a lengthy way of saying I'm not sure I trust the department at this point, and I want to see them judged on have they actually delivered after all this money after all these reviews, after the numerous people who've killed themselves, have they actually changed?
You did say that they responded well to such inquiries in a particular way without actually implementing any of the improvements. Just what was that way in which they responded well?
Well, I would read the results of these inquiries and I'd see the box ticked. And I'd say, yes, nominally we're sort of doing that. There is maybe a sub-team that does a bit of that, whatever it might be. Like, there might be a suggestion to integrate claims processes, and they say, the department has accepted and government has accepted this recommendation. But if you're actually on the ground seeing how that was playing out, it might be one team that was sort of doing a little bit of that, and business as usual was continuing for the vast majority of the work that was being undertaken. There's really, at least from the claims processing perspective, no sense of any substantive change between when I sort of left after the delivery of the memo report and when I returned. There wasn't a sense that things had actually constructively changed and that the issues had been resolved. And that sort of, I guess, engendered a bit of distrust about the thing, but also the idea that DVA seemed to be good at writing responses, putting into words what they've done, which might be very, very small, but making it sound bigger than it actually is. I'll give one example, if that's all right, that's specific, but I think relates to this idea that I sort of have about the whole thing, that there is a constraint of possibility that's occurred because of the poor performance of DVA, that the scope of what is possible has sort of, if you're familiar with the Overton window in politics, this idea of this narrowing of scope and this vision of what range of things might be possible, and I think that's occurred at DVA. An example is this idea that, for instance, the question, the 30-question questionnaire for activities that a service person has done has been removed from the claims process, and that's a real win. But even back when I started in 2012, it was really obvious that stuff probably didn't need to be asked, that there was enough evidence to deal with things in a better way than sort of specifically asking how many kilograms did you lift back in 1985. It was pretty obvious stuff, but the DVA will hold this up as, look what we've done. And that ticks some box on some report, but it doesn't have any practical impact on what happens within the department or what happens for veterans as a result of their behaviour. That's why I formed that view. We're at the point now as a society, as a country, we've actually got to say, what's the actual outcome, not what are you intending to do, because we've heard the intentions for too long.
You finally are reading from your statement at 18, you say, my drive to enhance the DVA stemmed from a persistent belief in its potential for improvement. However, as time went on, holding on to this optimism became increasingly untenable given the realities I face. How untenable did it become? What is your level of confidence that the DVA can be reformed?
Personally, it is very low. I still, I don't want to see it sort of reset necessarily for the sake of it, but I just don't have a lot of hope. And that was sort of washed out of me through those processes, through the sort of attempts to change, which was a little bit like bashing one's head against the wall, to be honest, and then coming back with a sort of different perspective for a short term, and just, as far as I could tell, nothing had changed. It's sort of, I had to internally sort of give up hope, I guess, and I haven't seen anything that's restored it that makes me think, oh well, the direction has really changed.
Thank you, Dr. Seidel, for your evidence. Commissioners, those are my questions. I understand my learned friend has some.
Mr. McCready?
Yes, thank you. In your evidence, you've said you've had these two periods of employment, the first from September 2012 until December 2018, and the second from April-May of 2020 to early 2021, and you achieved the position of acting principal medical advisor for a month in 2017, and then for the last year of that first period of employment, you were involved in as the subject matter involved in subject matter expert work, involved with the including the special operations program that you forces program that you've spoken about in your evidence this afternoon. When you returned in April, May of 2020 until 2021, your evidence this afternoon has been that you didn't see anything that indicated any significant change when you were then working as a CMA, Contracted Medical Advisor. Is that right?
Yes.
Yeah. Were you aware when you returned in April, May of 2020 to early 2021 of the study done by Professor Alex Collie in 2019?
Not that I remember. I mean,
Yeah. You're now aware that there was a study done by Professor Collie into the mental health impacts of compensation claims assessment processes on veterans?
yes.
Yes. And have you recently read a report on the Department of Veterans Affairs actions relevant to the findings of Professor Collie's study, dated the 30th of June of 2020?
Yes.
So that date, the 30th of June 2020, coincides with just after you'd returned to working as a contracted medical advisor. Having read that report, can I take you to the page 5 of that report? And I believe it now has an exhibit number.
Commissioners, I can assist. Could the operator bring up DVA.5042.0001.0396? I thank my friend for warning me he wanted to show it, and I apologise for dozing off when he got to the critical moment.
Thank you.
Yes. Yes, do you have that in the screen in front of you?
I do. If there's
Yes, if we can
possible
go,
to enlarge slightly, that would be helpful.
that's page 1.
It should be on the screen on your left as well, Doctor.
Oh, thank you. Oh, yeah, that might be a bit easy. Thank you. Okay.
If we can go to page 5 of that report. Now, at page 5, the Department of Veterans Affairs refers to expand combined benefits processing. First of all, can you explain what combined benefits processing is?
Yeah, so this is sort of the idea of reintegrating things. And so actually having the one delegate actually be able to handle ILPI NCAP. So it's the implementation of that idea.
All right. Now,
Can you identify the paragraph you're referring to?
sorry, it's the first paragraph under point 4 in the page.
Okay. The operator can then...
Well, it's the paragraph. The point 4 is expanded combined benefits processing. So that's what this passage of the DVA report is considering. Did you read this passage of the report, that is point 4, expand combined benefits processing?
Yes.
And when you read it, it indicates that apparently the Collie report had considered a DVA trial of combined benefits processing appeared to have delivered positive results in terms of veteran experience and so on. And then under the heading DVA actions on the same page, which is underlined, did you read the actions that the DVA reported it had done in relation to this?
Yes.
And in relation to that, a combined benefits processing trial for claims made under the MRCA Act was introduced into Brisbane and Perth compensation processing sites. I should stop there. When you returned to work in 2020 to 2021, what location did you return to work at?
I was working remotely for the Perth team.
The Perth team, yep. And recently expanded into Sydney and Melbourne. In the next paragraph, it reads, the CBP model means that for the same client and same claimed conditions, a single claims manager is responsible for different steps in the claims process, including investigating and determining liability claims, etc., etc. You understand all that?
Yes.
They then, in the next paragraph, DVA report observed benefits to date include efficiencies in end-to-end claims processing, that is, e.g. from initiation of liability claim to completion of permanent impairment claim, and increased claimant satisfaction related to a consistent point of contact throughout the claims process. You read that?
Yes.
And then the next paragraph, due to the substantial increase in MRCA and DRCA initial liability and permanent impairment claims since December 2019, CBP resources have been diverted to address the growth in claims and to alleviate the delays being experienced in claims processing. And then it goes on to say the diversion of resources may need to continue for the first quarter of the 2021 financial year, after which time the transition to increased CBP arrangements can continue. Whilst you were there, were you aware of any use of the combined benefits processing?
Not that I knew of, no, and then certainly most of the claims that I was addressing clearly had their liability assessed elsewhere and not by the delegate who I was working with on the PI claim. And
in terms of the discussion you had with my learned friend earlier this afternoon about the Department of Veterans Affairs being judged by its outcomes and rather than its aspirations, how does your reading of this fit in with that?
Well, I think there's something curious about it, which is, in one paragraph they say it improves efficiency, and in the next they say because they've got more claims, they're not able to do it. And that's sort of coherent with how a lot of these kind of small pilots and the ticking of the boxes would occur. You'd trial something in a pretty unstructured way often, whether or not it was unstructured in terms of how it was conceived or how it was delivered. And then as soon as there was any sort of hint that it wasn't quite working or you got some extra claims, you just abandon it and go back to business as usual. That was my impression of sort of reading that it sort of was, it sounded like any number of times that sort of things like that had been tried and then just very quickly abandoned. Not necessarily because they wouldn't work, but because it just didn't fit with the path of least resistance for the team, so the people who are managing those teams.
And you spoke in terms of box ticking reports. Do you see this response as fitting in with that sort of?
I mean, quite possibly. I mean, I'm not privy to whether or not the DVA has gone back and really reinvested in this way of doing things. But at least at that time, it does strike me as one of those examples of box ticking. We're doing this, but we've had to abandon it. We've sort of ticked it, we're doing this, and then a bit time later, but we abandoned it because we got more claims. So there were lots of those things. This exact sort of thing had sort of happened multiple times when I was there. They'd constantly rearrange the teams and sort of fiddle around trying different things, but without a committed vision of how to do it and without really structuring the business in a way that would make it work at scale.
Yes. Just one other matter. You, at the time of the SOF pilot that you've spoken about this afternoon, was a backlog of cases an issue at the department?
My view of a backlog of claims was always an issue. There was always immense pressure for processing. The entire time I was there were maybe 1 month or something where there was a reprieve and it seemed like things were relatively in control. But of course, how that gets achieved is partly via sort of claim splitting and accepting the wrong condition. I don't recall any point where claims processing and the department's capacity to actually meet the demand was not a really significant issue.
And did you see the SOF pilot program as having any application in terms of assisting with the backlog?
Well, absolutely. If you're willing to sort of learn those lessons in a constructive way and start sort of applying them across the department to really enhance efficiency and safety, then yes. Yeah, it's a way to, certainly a way to apply it.
Thank you. No further.
Thank you, Mr. McCready. Commissioner Brown?
Thank you, Dr. Siddall. Can I just ask a couple of things? I'm just curious in terms of, you were talking about the change of ratings that were made by, was it the medical advisors or the?
It would usually be the medical advisors who would change that rating, yeah.
And you said that, to the best of your knowledge, veterans were never made aware of those changes. I have to say, I've certainly actually physically seen correspondence where the changes have been very clearly set out.
Mm-hmm.
So I'm just wondering whether there may have been a change in that approach.
It's quite possible that there was a policy change. It's quite possible that sometimes some delegates put them in their decision sort of letters, and if you were to dig deep enough, you might be able to see the changes. But I was not aware of sort of any process where it was like, if we make this change, we must inform the doctor or the veteran.
Right. Okay.
In my time there, at least. Yeah.
And you talked about I think you were talking about the Melbourne office and how they increased their number of medical advisors. They were able to process things more efficiently, and then you said that perhaps was part of a process where they took on more work because they were working more efficiently. And you then said something about might increase the security of the office and increase the chance of promotions for the staff within it. I just want to understand, did people feel the security of their office was at risk? Was there some threat to people's jobs?
Well, there was even from the early days, there were conversations among the leaders about the potential sort of outcomes of all sorts of inquiries. At one point, some delegates were telling me they were convinced the department was going to be sort of shut down and be sort of folded into one of the other government departments. And certainly the leaders of the different sort of areas were, I think, cognizant that there was the possibility of consolidation, so that one area would end up doing all the processing work. Because in some ways, if you've got this kind of system going that acts on claims in the way the DVA does at the moment, like it does make sense to consolidate it into an area. So those discussions were things that would be had between the sort of at the EL1, EL2 level of, to my understanding, there was a recognition that there's possibility of consolidation, and one way to prevent you being the one that gets removed as part of the consolidation is to start absorbing as much work as you possibly can.
Yeah, okay, thank you. That's kind of helpful, giving some bigger picture. In terms of the issue you raised, which I think is a very valid one, about potentially ordering tests but not reviewing them in a timely fashion. I guess I'm wondering, was there anything to prevent the advisors actually addressing that by, as Mr. Singleton suggested, actually copying in the treating medical practitioner on the request so that they got a copy, potentially sending a copy to the veteran themselves?
Yes.
potentially sending a letter to their GP saying, I've ordered this test, can you please review?
Yeah, so it's an obvious solution, but one of the things that we tried multiple times to clarify with the department, and not just myself but other advisors, was what was the actual position on confidentiality around that? Did we actually, if we were requesting this in the context of a medico-legal report, could we actually release that information directly because it was clinically sort of relevant? Without a clear answer to that, my my indemnity insurer said, don't do it. And the department never provided a clear answer as to whether or not we could sort of undertake those actions by default. There was a clear duty of care if something was, seen on those reports, but as to whether or not we were able to see them up front.
So, but wouldn't the consent rest with the veteran, not the department?
But someone has to get the consent from the veteran to do that, and the department wouldn't engage the issue. So it's not, the advisors are not in direct contact with the veteran. I guess it could be implausible that every time we did it, we rung up the veteran, but then we're establishing a sort of a clinical relationship with the veteran for the purpose of just that. It would have been helpful if the department said, look, we can get consent up front for you to share this information, but they simply never gave us that assurance that would happen, and that was okay.
So then, can I just ask about the training of delegates? And I appreciate this is not your area, but I just wanted to have your sense of it. Were the delegates being appropriately trained in your view in terms of things like what is the standard of proof around, for example, the risks of accepting the wrong condition? What training did they get, and did you have a sense that it was anywhere near adequate?
I can't say exactly what training they got. I can say I had a sense that it wasn't adequate, and that came directly from delegates saying that. It wasn't like I made the judgment that the delegates were sort of terrible. I did see a poorer quality, I guess, of questions, but the delegates would openly say, we don't get enough training and we're being pushed to just do more and more claims and we're not able to do it. A side note to that as well, the other thing that would be said that they didn't have adequate support and training to deal with some of the sort of mental health issues that would arise, where they didn't have adequate support to sort of deal with distressed veterans on the phone and things like that. And I remember conversations with delegates who were sort of looking to the doctors for support because they just had a veteran on the phone who was suicidal or very distressed, and they'd never been prepared for it, not something they're trained for, but they were having to deal with it, and they didn't feel like there was any support within their normal hierarchies, so they were sort of, I guess, going to us for that supporting structure.
Okay. So you've painted, I guess, a fairly damning picture of the department. Do you have a sense of how widely shared your views were with your medical colleagues?
I don't necessarily want to speak for them. My sense was that no doctor I knew who worked there in terms of the, I guess what I call the old guard, I'm not really sure. I think they were pretty content with how things were operating. Of all the other doctors I've interacted with, I mean, it was sort of an openly understood that the department was pretty poor in how it handled a lot of things. It was not like I was a renegade within the medical advisor team for these views whatsoever. I was very different in willing to risk sort of the reprisal and the career problems that might have arisen from sort of raising the issues. But apart from that, I mean, they may disagree with specifics, absolutely. I doubt that many of the people I knew would disagree with the proposition that the picture I've painted is probably fairly reasonable in terms of what it was like to work there.
So, sorry, you referred to the old guard. So how old are the old guard? Is there a kind of a period of time whereby things were different?
Yeah, so when I arrived there, I mean, most of the doctors who I was working with, I think it was a team of 5 or 6 in Melbourne, I think the shortest time anyone had been there was for over a decade, and some of the doctors had been there, I think, since the 70s or 80s, long service for the department, had been departmental advisors and then pushed into being contractors. And yeah, I think they were relatively content with the approach taken, but it was very different. And when I first got there, it was actually a bit slower as well. That the Melbourne team was smaller. It was just a different sort of approach to the work, basically. But the queue was out of control, partly because of that, because there'd been a bump in claims, I think, and they would approach things very slowly, very cautiously, in terms of how they actually did the opinions.
Well, perhaps my next question was going to be, is there or was there during your time a high turnover of advisors? Medical advisors?
Not as a general rule, so a lot of all the 6 eventually sort of retired, although one of those advisors stayed with us for many years. There wasn't a high natural turnover, but there was certainly a loss of a lot of advisors when the contract was awarded to Bupa. I think the largest loss was sort of in Sydney, with a lot of the advisors just, refusing to accept that deal. Day to day there wasn't, and that's partly because as a job, for all the problems, it's not a bad job for a doctor in terms of it being, relatively stable hours, friendly for people with families. Within the doctors, a relatively supportive environment between the doctors, so there's less of the sort of, some of the things you might encounter in a hospital or a medical hierarchy. We sort of made sure that wasn't really going on too much. So yeah, doctors might recognise the place was not really doing that well, but in their own personal lives, it made sense to stay.
Can I just turn to the Special Operations pilot, and you said that it was a lot quicker. I mean, you weren't able to quantify that. I'm just wondering whether you had any sense of the cost. You said that one of the things that was said before and potentially afterwards was that it was too expensive. Do you actually have any understanding of comparatively per claim?
No, I don't. I believe that the part of the soft analysis was to look at some of that, but I never saw any analysis on the other side. It seemed to be back of the envelope stuff, basically saying it was too expensive. And in the meetings I was part of, where we weren't looking at numbers and saying this is too expensive, it was, no, that's too expensive. But I obviously don't have the report, so I can't speak to any objective numbers there.
Okay, I think it's probably important for this commission to see those numbers.
Absolutely, yeah.
Along the same lines, you talked about the combined benefits processing. I'm just wondering whether, because you described that as having, one delegate dealing with the IL and PI, is that something that you see came out of the Special Operations pilot? That it wasn't the complete picture, but it was part of what you were aiming for in terms of better integration?
I'm honestly not sure. The Special Operations pilot and the MEML project made the same recommendation, and we weren't the first. It's impossible for me to know what the core motivation of that was and whether it was really a learning from the soft pilot.
It does sound like it could have been.
Sounds like it could have been, but as I said, I think you would probably see other things prioritised along with that if it was coming out of the soft pilot, like a model like the soft pilot still existing somewhere for those more vulnerable veterans. That would be the most obvious thing you'd do if you had looked at the soft and seen it as a success. You'd say, well, we're going to at least have that system for the most vulnerable, population of veterans and for escalations and things. So I guess if you saw that as well, and then you saw these other things, yeah, maybe they did learn the lessons and deploy them. But if it was just that in isolation, I'd say that's a sort of strange pocket lesson to learn out of of all the things you could have taken out of soft.
Yeah. And again, I'm not clear, but I'm aware that there is a complex claims or complex cases. I'm not sure the terminology, but that's something we'll have a look at.
Oh.
Look, I probably won't ask that.
Right.
the next one's probably a comment more than a question, but you said your sense was that DVA's response to some of the recommendations was a response without really actually changing anything terribly much. I guess my comment was just that we have made commentary previously about the number of reports that preceded this Royal Commission, the number of recommendations, and not necessarily seeing a lot of change. So perhaps the observation applies more broadly than just DVA. You said that you need to see actual change and outcomes before you really could believe that DVA had fixed anything. Do you have a sense of which, actual outcomes, what actual change you would need to see before you could be convinced that they were on the path to the right?
So some of it, I think, is sort of objective things. Like, I understand there's a major sort of compensation and claims backlog at the moment, a huge queue. I would not have expected to, after all the sort of investment and work done in trying to optimise those processes, I would not be expecting to see that continuing for any length of time. And I'm sort of surprised that it would have occurred in the first place if the department sort of as a whole understood what it was doing and how to structure its processes efficiently and make sure it was ahead of resources requirements, not sort of constantly falling behind and scrambling for things. That's sort of evidence to me that it's not going, it's not necessarily changed. I guess the other thing is, you'd be expecting to see the veteran community and those, those people really saying, hey, things are really different. We're much happier with how things are happening. I don't, I'm not a stakeholder in that community, so I'm not sure. But that's one of the things I judge it by. And I only get the impression from these proceedings and some of the other submissions I've watched and read that doesn't seem to be the case. And then the other thing is, I would expect some of those submissions around delegates and things to not be describing the same issues that I'd seen when I was there around delegate training and the circumstances they're working in. I would expect, I guess, I would want to see those things not be an issue and to have sort of delegates, veterans, saying this is actually going really well, and there to be a sense that there was now a purpose to sort of start optimising and improving the well-being of the veteran community. I'm not aware of that at this stage, so that's why I'm not reinvesting my hope in the department.
So I said before you painted somewhat of a bleak picture. If I could just put to you, it sounded like a dysfunctional department with poor leadership, a powerless secretary from your account, a kind of blame culture that wasn't focused on veterans, with a lot of disempowered staff amongst a few powerful warlords in the fiefdoms, and not terribly open to innovation. Is that a fair description of your experience?
I think so. I would not necessarily describe the Secretary as powerless, but in relation to these broader changes, it's probably not unfair. It's not like the department completely ignored the Secretary or the upper executive, but when you talk about what were the issues here, I think it's not an unreasonable characterisation, and the rest of it, yes, that was my experience of the place.
Okay. So, Council asked you essentially, can it be fixed? And you, I think, said something along the lines of you don't hold out great hope. I'm perhaps verballing you a little bit.
That's right, yeah.
What would the ideal system look like? And can, just before you answer that, can I ask, because one of the questions in my mind, listening to you was talking about the problems and the lack of understanding. I thought, well, maybe you're saying we need more medical advisor input, but then in the latter part of your evidence, you were suggesting that perhaps you'd need less if it was well functioning. So what would it actually look like if it was a well functioning system?
So it's obviously a very broad and deep question, so I'll try and be, I guess, as brief as possible in terms of how I'd say it. I think there's different layers of it. The first thing I want to say is a well-functioning system would be able to take into account the voices of people like Julianne Finney, the Bird family, and veterans who suffer in a really proactive, responsive way in real time. And I think having that sort of responsiveness to their experience and to their emotions is absolutely critical to getting this right. That there was definitely a deep sense in the department that emotions were just something that happened at home, and they weren't relevant to claims, but they also weren't relevant to how people were actually experiencing their life working for the department. It's a very difficult task to do this, but we need to find some way to actually have a soul, if I can use that word, and a purpose that takes into account that these are real lives and real things going on. These are not abstractions. Every claim relates to a real human being and a real outcome. I know that's big, but I think that has to be underneath everything. Otherwise, we'll just end up in the same sort of situation. I think in terms of more specific structural changes, I would advocate for almost total decoupling of health and compensation. So I know some of that's been done already, and I know there's going to be arguments about how much it's going to cost. But if you were designing an ideal system, I think you would actually have one IT infrastructure that can share that information, because it's all the same medical data for sort of compensation and for also looking at well-being. But other than that, you would want the interdependence between those two things to be as low as possible. So instead of having a claim derives your access to particular treatments, I would like to see a model adopted where really we just get in there and invest in whatever solutions can be found to improve the well-being of veterans without worrying too much about, is that particular medical condition we're treating right now specifically related to their service? That's just me, but my personal view. I understand there might be a cost to it, but I would also argue that doing that and actually achieving that would derive very valuable learnings about how you actually do improve the well-being of populations, how you work with trauma, how you deal with chronic pain, and might derive a benefit in terms of overall people being less impaired and then less money having to be spent on compensating them down the track. In terms of IT, it's pretty simple. We have to figure out a way to run a publicly funded IT sort of project and get it right, do it in a timely fashion, and have it structured as fit for purpose, not something that reflects the existing systems, but reflects a first principles understanding of what do we need these systems to do. That is not what DVA has, and I think DVA has acknowledged that. That might not be entirely their fault, but that's the situation we're in. That has to be rectified. This doesn't get solved without proper investment in IT and a really well-run project. And the last thing is, I think deep consideration has to be given to decoupling whatever institution does this from ministerial control. That's something I didn't touch on here too much, obviously, but I think the role of the minister could be destabilising, and that's not a knock on any of the individual ministers who I think, by and large, trying their best. But you certainly knew, I think I was present for 6 or 7 ministerial changes. You knew when they happened. They did have a destabilising effect on the culture. But also I think that sort of process of really being driven by time taken to process and these sort of metrics that you report to Senate estimates, as opposed to having an intrinsic service about serving the community, destabilises and makes it hard to have a culture of excellence. So I think consideration needs to be given to the organisation actually being still transparent, but being independent. My view is where we see these real cultures of excellence in public funded institutions, they do have a degree of independence, whether it's commissions or whether it's public schools that really do well, whether it's hospitals that really serve their communities. They're not necessarily beholden directly to a minister. They're invested in their community directly. If there's a way to achieve that, I think that might be better than sort of continuing on that the allegiance is really to the, via the secretary. And I'll add one last thing, whatever the organisation looks like, a strict chain of command would not be a feature I think is necessary for the organisation doing this work. I understand potentially in defence that makes sense. I won't make any comment there, but in terms of the department, they had a really strict chain of command, and I think that was pretty destructive. So I'd like to see a much different organisation that's...
Can you just explain that a bit more? What do you mean?
Oh, I mean, delegates were very delegates could not go outside the chain of command. If you've got a problem, you've got to speak to your team leader. Your team leader's got to speak to your EL1. Everything's got to be escalated via that. And if you go outside of that, you're in trouble. And the same was applied to the doctors. I mean, that was applied to us when we would try and raise things with the principal medical advisor, and we're accused of going outside the chain of our command because our immediate boss was the EL1 or 2. I guess what I'm painting a picture of is a very, very different organisation, but they're the kind of structural things I'd say is really important in a very brief time.
Thank you very much.
No worries.
Thank you. Commissioner Douglas.
Thanks very much, Doctor, for your evidence. Were you there when the Productivity Commission made its report in 2019?
I'm well aware of the Productivity Commission report. I think I was, but I can't recall exactly the date that came down, obviously. I was well aware of the report.
I don't know if you can recall some of its recommendations now, but I could remind you of some of them.
Yeah.
One was to move the administration of the Veteran Support System out of DVA into a newly created statutory agency, a Veteran Services Commission. Another was to levy an annual premium, I think on defence, to fully fund the future veteran support system, moving veteran support policy into the Department of Defence and creating a new veteran policy group, maintaining a single Minister for Defence Personnel and Veterans, and a couple of other things, including a new advisory council, and they developed them. Did you have any views about them at the time or now?
At the time, I can't recall. Now, most of it sounds reasonable. Did I hear in there that one of them is to sort of nest these services within Defence? Is that?
No, create a separate
It would be
Veteran
separate,
Services Commission.
Yeah, I mean, I think that's I guess I would agree that at this point that might be a better way forward and would obviate some of the concerns.
Probably, from recollection, I haven't reminded myself fully of it yet, placing the administration of entitlements or benefits elsewhere.
Yes, I think it's difficult, I think, to do that entirely, but I think that would be the ideal situation if you can, and that is legislative change, but if you can legislatively decouple it and sort of really have a different focus, then it may be better to have them as operating separately. One of the issues, I think they should share an IT infrastructure because they're going to use the same set of data.
Yes. I was intrigued about the role of you and your medical colleagues. Is it on the whole simply advising on medical issues of claimants?
Yeah, just at least, in the areas I worked in, it was literally helping the delegate with any medical questions they had in relation to claims processing.
Have any people with medical qualifications infiltrated the administrative side of the department?
Not really. I mean, there's the Chief Health Officer sort of role now, so I guess there is maybe a little bit more, but not to any discernible degree that I could say, and probably not enough for what you would expect as a health organisation. There is some other, there was a great psychologist who worked in Canberra. I can't remember exactly which role she was in, but there were some people of that nature in roles, but not really. There was a distinct lack of a sort of understanding of medical systems and healthcare, I felt, among the leadership group.
Might that help with issues such as splitting of claims and acceptance of the wrong condition?
I think it would. I think it would help culturally, and I think it would help with the department's understanding of risk. So the department's risk sort of, the way of assessing risk really comes, I think, out of business culture and a sort of sense that if most things are right most of the time, that's okay. And a lot of the discussions I would have would be, we actually have to, there's another view of this, which is more what you see in healthcare, which is we need to account for catastrophic risks at every level of the processing, and that was sort of something that seemed quite alien to the staff I would speak to about it, to the leaders, that actually when we're running this kind of organisation, catastrophic risks, while rare events really matter and you need to account for them in the system.
I think you described it as essentially a health organisation in your statement.
I think it should conceive itself of that. I think there's argument about whether it currently is, but I would see that the future organisation that it would be better thought of as primarily a health organisation, and maybe claims is still part of it, but they would be a sort of subset of the work it does, and the identity should actually be around health.
Finally, a point of detail. In paragraph 96 of your statement, you refer to the enzyme group. I've got a feeling we've heard some evidence that it was a group called in to advise on culture, was it?
Yes, yeah. So they did a wide range of reports around the organisation.
When did that happen? I think we've received evidence about it, but I've forgotten the detail.
So it would have been happening from at least, I think, 2015 onwards. They were involved. I think I probably met them. 2017. So I think I probably met them around 2017. I think they had ongoing work for quite a while, providing a bunch of insight and reports into the department.
Thanks.
Thanks, Doctor. I just have a couple of issues to raise. I think we're aware that there are about 18 conditions which the DVA is catalogued as where they will accept liability sort of automatically. I just wanted to get your views on that. It obviously seems to be something that's helpful. Should that be expanded or looked at to see if it can be applied in other areas? Or
Yeah, I mean, I'll admit my view on this is somewhat radical, but I think we should be automating the vast majority of claims because I think that's possible. Most of the claims fall, into some large categories. And when you've got the statement of principles there, when you understand sort of activities that were occurred during service, and you can externally verify medical evidence to get those diagnoses in place, if you build that IT infrastructure that allows that, I don't see a good reason why you can't actually automate the acceptance of most things. Maybe there's some vagaries of, say, circa if we don't get consolidation that make that difficult. But certainly within the MERCA space, I see no obstruction to basically automating as much as you can and just applying random sampling and risk sort of mechanisms to only sort of manually look at the ones that fall out of what you might expect.
just in support of that, our sense at the moment is that there is a very low rate of fraudulent claims. Would you agree with that?
I saw no evidence that there was any significant degree of fraud while I was there.
Which would support your suggestion that there's more of an argument to actually approve things rather than find reasons not to pay.
Absolutely.
Or to approve. Okay, thank you. You mentioned the consent issue as we discussed, and I think you said something along the lines of the fact that the department was reluctant to engage with people on that issue. Just engagement generally, what's your sense of how engaging the department is with human beings, just to sit them down and talk to them about the various steps that you've gone through today and the torturous processes they have to go through?
So as someone in the department, it was incredibly difficult, and I think I referenced in the statement that unfortunately I had to sort of assume the identity of a political sort of operative, which is not really my natural inclination, and really had to be very strategic. It was hard work to get anything done. My sense in terms of their engagement with external stakeholders, so I saw some of that engagement with, say, the independent medical examination providers. It was very lax in terms of the way they managed those kind of contractual relationships. Like we might have an occasional meeting once every 12 months that really provided no performance management. And then my impression of the way they would relate to veterans and other stakeholders was that there was a similar sort of, it was not very productive. I said, at the time, and one of my sort of enduring impressions of the place is that they are distinctly poor at relationship management of all kinds, and that comes back partly to their misunderstanding of their own responsibilities and the difference between blame and responsibility. I don't think the department in some regards, and unfortunately this might not be a problem isolated to the department, but is somewhat immature in that regard, that it didn't, if something had gone wrong, it didn't want to see that there were responsibilities that it had. It wanted to say, we're not to blame, so we're not responsible. Does that make sense? So essentially, my view was they're very bad at managing relationships of all kinds.
Thank you. Just one final issue. The SOF pilot, we've discussed it at length today, but what was there an official reason in writing anywhere about why you didn't proceed? What was your understanding?
Not that I'm aware of. My understanding is it just hit the wall of sort of middle management and didn't proceed, just didn't get rolled out and got sort of wound down. But there are others who are really well placed to sort of describe that in detail.
Okay. Thank you. Thank you. Mr. Dighton, any questions?
No questions. Thank you, Commissioners.
Mr. McCready, any matters arising? No. Thank you. Mr. Singleton.
Nothing arising. Might the witness be excused?
Thank you. You're excused from your summons to appear, Doctor. We just want to thank you for your evidence today and a significant amount of preparation you've obviously put into your statement today. We appreciate your candour in particular. Thank you very much for your evidence. If there's no other matters, I think we'll adjourn to 8:30 tomorrow.
I can't speak for such an outrageous time, but we have no other matters today.
Thank you. We'll adjourn.
All rise. The Royal Commission into Defence and Veterans Suicide will adjourn to 8:30 a.m. Thursday, the 7th of September.